Morning, thank you.
Good morning.
Morning. I do solemnly,
I do solemnly,
sincerely and truly
sincerely and truly
declare and affirm that the evidence I shall give
that the evidence I shall give
shall be the truth,
the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Good morning. Could you give us your full name, please?
My name is Victoria Sheila Reynolds.
And what is your job title?
So I'm the head of asylum advocacy at Freedom from Torture.
And what does that role involve in particular?
So I work with clinical and legal colleagues across the organisation and across our 5 centres to pull together evidence and expert analysis of the experience that torture survivors within the UK have of the UK asylum system, their access to protection, and any issues they may experience as torture survivors seeking asylum in the UK. And I make representations to the government and other influencers and decision makers to try and make improvements to the system for their benefit.
So Freedom from Torture as an organisation, what exactly does it do? What are its aims and objectives?
So Freedom from Torture is a UK-based human rights organisation and one of the largest torture rehabilitation centres in the world. We provide clinical services to more than 1,000 torture survivors in the UK. As I said, the vast majority of whom are asylum seekers or have refugee status. We also do campaigning work, so that includes the advocacy work that I'm responsible for, which involves working alongside government counterparts to try and improve the asylum system for their benefit. We also do public campaigning work, so we work with our supporters and members of the public to campaign for better treatment of torture survivors as asylum seekers in the UK.
Does Freedom from Torture provide medico-legal reports to formerly detained persons?
Yeah, so one of the services that we provide is the forensic documentation service. So our medico-legal report service provides expert documentation of torture for people who are referred to us by their legal representatives. They may be referred to us from detention or from the community. We don't provide medico-legal reports. We don't go into detention to document torture. So someone needs to be released from detention and then they can be referred into our service and we can do a medico-legal report assessment and produce a report for them if they meet our intake criteria.
And for what purpose do you provide medico-legal reports to those people?
So it's to inform the asylum decision, mainly. So we'll be instructed by the legal representative where someone has an asylum claim ongoing, and documenting their experience of torture is an important element of their asylum claim, or will contribute to helping the decision maker to make a decision on their asylum claim.
You also mentioned in your statement that Freedom from Torture has safeguarding policies. What is a safeguarding policy and what's the purpose of those type of policies?
So our internal safeguarding policies help us to deliver on our own safeguarding obligations towards our clients. So protecting our clients as at-risk individuals, to ensure that we do no harm in our own service delivery and to enable them to live lives that are free from harm and neglect. They assist us to work together as an organisation, but with organisations, partner organisations, to prevent and stop the risks and actual experience of harm that our clients might have. It's about managing our clinical risk so that in the work that we do not do harm to our clients.
And does Freedom from Torture also provide training for organisations?
Yep, we do. We provide narrative exposure therapy training to IAPT services, and we do training on engaging with survivors of torture for voluntary sector organisations.
Thank you. You mentioned that you don't have a particular role in going into immigration removal centres. Do you have any particular role in the detention in immigration removal centres at all, or is it only after people have been released?
So we interact with the detention estate at sort of two key points. So we may be alerted that one of our therapy clients, so someone receiving therapy with us or being assessed for therapy with us, has been detained. Or we might get a referral from a legal representative of someone who is in detention but hasn't previously been one of our therapy clients. And that's in the circumstances I just described earlier, around where we have been asked to produce a medico-legal report. So in those circumstances, we can do an assessment of the documents on the paper to see if the individual meets our remit and if we think there's something to document, and then we will advise the legal representative to make a referral to us after release for us to do a medico-legal report. In the context of a therapy client who has been detained, if we are alerted that that someone has been detained, then we will usually write a letter from the treating clinician at Freedom from Torture to the clinical team at the IRC, so a professional letter from one healthcare professional to another, to alert them to the fact that individual was a current client of Freedom from Torture, was receiving therapy with us, confirming that they are a torture survivor, and any details that we have or concerns that we have around the risk and the mental health needs of that individual. We will also often comment in that letter on our concerns around the risk of detention, especially if we think that the being detained will increase the risk of harm to that individual.
You've mentioned various different ways that you might be alerted to a victim from torture or a torture survivor. How do individuals who are torture survivors access your services? What's the referral process?
So we have an open referral process for our therapy services. Someone can self-refer for therapy with us, but we mostly receive referrals from other healthcare professionals, usually from GPs.
Moving on then, Freedom from Torture submitted a document entitled Freedom from Torture Submissions to the Brook House Inquiry, to the inquiry. You prepared that document, I believe, with Zoe Cross. What's Zoe Cross's job title?
Zoe is the Policy and Administration Assistant in the Policy and Advocacy Directorate at Freedom from Torture.
And what does that role involve?
She provides administrative support to the team, and she provides additional policy analysis support to me on detention policy issues.
In those submissions, you've come to some conclusions on the effect of immigration on victims from torture, and you've particularly looked at two case studies which have been anonymised, and we'll come to those in a moment in more detail. Those case studies are in relation to two former Freedom from Torture clients, is that right?
Yep, so one was a therapy client and one was referred to us from detention for a medico-legal report.
And Freedom from Torture has declined to provide the inquiry with their identities. Those are anonymous case studies. Why is that?
When someone is referred to us, they provide consent at that early point. That's a generalised consent that allows us to use anonymised data for non-identifiable purposes for research and policy. So that is the level of consent that we had from these two individuals that allows us to use their data to the extent that we have within the submissions for this inquiry.
Thank you. You've also, in relation to those case studies, looked at various sources of information, and you've set those out at paragraph 5 of your statement. You've looked at some Rule 35 reports, the Home Office response to those reports, is that right?
So we looked at we looked at the Rule 35 and the Home Office response within the 2 case studies, but we have also previously done more generalised analysis of Rule 35s and Home Office response to Rule 35s for a wider case set that we submitted to the Independent Chief Inspector's inquiry into your second inspection of the adults at risk.
Yes, and also in relation to these 2 case studies, you looked at any other information, including any other clinical reports, and really any other information that you held upon your system in relation to that.
That's right.
Before we come to those case studies in more detail, you set out at the bottom of page 1 of your submission that clinically it's well understood that torture survivors are particularly vulnerable to harm in detention. From where have you drawn that conclusion?
So there have been a number of systematic literature reviews that have been done over the years looking at clinical and legal literature, including a mental health literature survey that was commissioned by Stephen Shaw for his initial inquiry into adults at risk in immigration detention. So we have relied on a number of those systematic reviews to form our opinions.
What is it that renders torture survivors particularly vulnerable to detention, then, in your view?
So I'm going to restrict my comments to the clinical opinions that were provided in our witness submissions. I'm not a clinician myself. But as we understand it, it is recognised within the literature consistently that immigration detention is harmful to mental health, and that if you have, for those who have a pre-existing mental health issues or experience of trauma, including torture, that detention can be, that the impact of detention can be even, the harm can be even greater. The degeneration of mental health and the symptoms can be even more severe with a history of trauma such as torture.
So it's freedom from torture's experience that, in particular, victims of torture are vulnerable to adverse mental health outcomes, to deterioration in their mental health whilst in detention.
Yeah, we've seen this both in the 2 case studies that we put into our submission and more generally in the work that we do, that our clinicians do with survivors of torture, including those who have experienced detention, that the effects of detention on those, detention can be extremely re-traumatizing. It can result in intrusive recall of memories of previous detention and torture. It can lead to nightmares, depression, PTSD, anxiety, and that these effects worsen the longer that someone is in detention and that they endure after release.
At the bottom of the first page of your submissions, you say that the 2 cases are illustrative of systematic problems faced by individuals, including survivors of torture who have been held in immigration detention across various IRCs, and you say over a long period of time. So firstly, what do you mean by a long period of time?
So we've been working on this issue, well, certainly myself, since around 2015, 2016, and looking at the failures of the safeguards to protect vulnerable people in order to feed into Stephen Shaw's first inquiry, which was in 2016. We have since then been monitoring closely the effectiveness of the Rule 35 process, how the Home Office responds to Rule 35 reports, the adults at risk process. When it was set up, we've been closely monitoring ever since the way that the levels of risk have been used and the balancing with immigration factors. And we've been engaging very closely with the Home Office on reforms to those processes as subsequent inquiries have highlighted failures in the implementation of those safeguards.
And so those are the types of systematic failings that you've just referred to, that you talk about at the bottom of that page. Yeah. And in relation to the liaison with the Home Office, has that been over the period since 2015, 2016 to date?
Yeah, so we have been engaged. We are, Freedom from Torture is a member of the National Asylum Stakeholder Detention Subgroup, which is a regular meeting between the Home Office, detention officials and NGO stakeholders. We were a member of that, so we engage with them at that level, but also on a bilateral level on particular issues to do with, for example, issues with Rule 35, issues with healthcare screening, issues with the use of medico-legal reports to inform adults at risk decision-making, and the reforms they wanted to make to that, including on the introduction of quality standards for medical reports. Most recently, that's the engagement, and also on the enhanced screening tool.
And as part of that process, do you submit evidence or written submissions to them?
We do, yes.
And do they respond?
Sometimes. Sometimes. Engagement with the Home Office on detention matters has not always been easy. For example, communication channels sometimes break down altogether. We've had periods of time where the detention subgroup has not met at all. We've found in our conversations with them through forums like that they will put fairly tight constraints on what can and cannot be discussed. And particularly when it comes to policy matters, there is a general sense that they are at one end of a spectrum and they believe us to be at the other end of the spectrum. And it's difficult, therefore, to find common cause, common ground on which we can make progress for the benefit of vulnerable detainees.
Do you feel you are making progress?
I think that the Home Office has been on a bit of a journey, certainly since Stephen Shaw's inquiry, and it has made a lot of effort, certainly, to learn about vulnerability and to learn about safeguarding. It's become very fluent, I think, in the language of vulnerability and safeguarding, and it has done a lot to build an infrastructure, both policy and operational, to try to implement that. My perception is that that is undermined by a preoccupation with abuse of the safeguards that have been put in place, which then has led to efforts to restrict access to those safeguards, which then renders them almost inaccessible to the people who really need them.
Thank you. Let's look then at the case studies in a little more detail. You first deal with the case study 1 on page 2 of your submissions, and this relates to an individual who you've referred to as Alex, clearly not his real name. And he was detained at Brook House for a 28-day period from early April 2017 to early May 2017, so at the beginning of the period with which the inquiry is concerned. And afterwards he was detained at Harmondsworth, is that right?
That's right.
You then set out that the asylum policy instruction on the Rule 35 process, that's DSO 09 of 2016, and perhaps we can show that on screen. It's FFT 502. That's the instruction that you're talking about. And can we turn to page 10, please? Perhaps just zoom in slightly. This instruction explains that shortly after the arrival of detained persons at an IRC, all detainees are, as part of the admissions process, given a healthcare screening, which includes being asked whether they've been tortured, and that this healthcare screening should happen within 2 hours of arriving in detention. Is that your understanding?
Yeah, that's my understanding of how it should work, yes.
And do you know whether the staff undertaking this screening have been given any definition of what constitutes torture?
No, we're not aware of what they've been provided by way of understanding the definition of torture.
Presumably, in your view, they should be provided with a definition.
I would have thought so. If you're asking somebody whether they've been tortured, then you should be able to understand what you're asking them and the response that they're providing you with.
You say that any individual who discloses that they've experienced torture must be provided with a follow-up appointment with a doctor as quickly as possible, during which the doctor will assess whether there are concerns that the individual is a victim of torture. Is that right?
That's right.
Perhaps we can just look on screen at CJS 000731, please. This is the Detention Services Order 08 of 2016, which deals with the management of adults at risk in immigration detention. And if we could... there's the DSO. If we could just look at page 8, please. And if we come down slightly in the page, there we find that all detainees must have had a medical screening within 2 hours of their arrival, which we've just dealt with. And it goes on to say, at 5 lines down, every detainee identified as an adult at risk must be given an appointment with a GP within 24 hours of admission to an IRC, which should include consideration of any medical requirements to enable removal to take place as planned. That paragraph doesn't mention Rule 35 at all, does it?
No, but my understanding is that's the Rule 34 appointment.
Let's just look then at Rule 34. If we show on screen CJS 006120. So these are the detention centre rules. That's the first page. And if we look at page 11, please. And zoom in on 34. Marvellous. So Rule 34, subsection 1 says every detained person shall be given a physical and mental examination by the medical practitioner or other registered medical practitioner within 24 hours of his admission to the detention centre. Is that right?
Yes.
So in fact, what Rule 34 requires is that every detained person should see the doctor within 24 hours of admission, not just those who disclose a history of being a victim of torture or those identified as an adult at risk in the screening. Is that your understanding of that rule?
That's how I read it.
The instructions, the asylum policy instructions, the 2 DSOs we've looked at, don't seem to reflect that, do they?
No.
Rule 34, requiring a GP to examine within 24 hours, would you view that as key to the Rule 35 process, because it's only a GP who can make a Rule 35 report?
Absolutely.
So it's an important safeguard in identifying those who are vulnerable early on in detention that has not been identified as that previously.
That's correct.
And the reason for undertaking that process, part of its purpose, is that whether someone is a victim of torture or not is intended to be factored into the decision by the Home Office of whether that person should be detained. Is that right?
That's right.
What is your experience, or Freedom from Torture's experience, of whether decisions to detain or maintain detention are properly informed by information from the detention centre about vulnerability?
So we've long had concerns about the quality of the Rule 35 process and specifically of Rule 35 reports themselves, but also access to Rule 35 reports. So additionally, within those rules, there is a requirement that the individual consents to that assessment. And I think there are issues around uptake of Rule 34 assessments by individuals who are extremely vulnerable and least able to advocate for themselves. And so I think the people who, I think that not everybody who needs a Rule 34 assessment is getting one. I think they are having historically had to wait a long time to get an assessment and then to get the report done. I think the quality of reports has not always been to the standard that we would expect, and I think the reports within the case studies that we've submitted show how Rule 35 doctors do not, Rule 35 report writers do not always comply with the requirements or the instructions for completing a report, including providing a comment on the impact of detention or the risk of harm caused by detention for the individual. That is frequently, in our experience, left out of the report. They often miss evidence, scarring that we later pick up in our medico-legal reports, and we can put some of that down to the length of time that they have to do the assessment, but also their level of skill in doing it. It's not, Rule 35 is not a medico-legal report, I should be clear on that, and it's a it's a much lower evidential threshold that the Rule 35 has to meet, but even then, Rule 35 doctors are often missing evidence of torture when they do them, particularly psychological. And then, of course, in the response that the Home Office provides to the Rule 35 report, we have seen historically many flaws in the way that the Home Office engages with those reports. We would expect a Home Office caseworker to identify any information that's missing. So if key information is missing from the Rule 35 report, such as the impact of detention on the individual, then the Home Office caseworker should return that report to the doctor and ask for it to be completed in such a way that they are in a position to make the best decision on the ongoing detention of that individual. We have not seen that happening in our experience consistently. And then the way that the Home Office engages with the information in the Rule 35 report in making its decision. This is often around the extent to which or the way in which they use the evidence to establish the level of risk that the individual is exposed to and where that puts them within the adults at risk process. So we see the Home Office making judgments that clearly place far greater weight on the immigration factors that form part of the balancing process in the adults at risk than they do on the evidence that even the barest evidence that's in the Rule 35 report of an experience of trauma and therefore an indication of clear vulnerability. And we see people consistently being rated at levels lower than they should be, so put at level 2 on the adults at risk on the back of a Rule 35 report, often because there is no declaration of impact of harm on detention because the doctor didn't include it and the Home Office caseworker didn't chase it. And then what should have put the person at level 3 sees them being rated as a level 2 instead, which we think is a significant failing within the Rule 35 and adults at risk process.
Thank you, and we'll come to some of those a little later in further detail. Just looking then at Freedom from Torture's experience of the Rule 34 assessment with a view to a GP preparing a Rule 35 report, has that become something that effectively a detained person has to proactively ask for, rather than it being an obligation under Rule 34 for every detained person?
It does seem that there is an inappropriate level of sort of obligation or onus on the individual to self-advocate in order to secure a Rule 35 report. And this is even, I suppose this is even more the case when they have already been through a process like a Rule 35 and either it hasn't been documented, because if it is purely self-declaration, then the Rule 35 doctor is under no obligation to produce a Rule 35 report. So unless they have something additional to an individual's self-declaration, then they don't have to produce one. And by our understanding, that even a self-declaration should provoke a duty of inquiry by that doctor. So whether or not they produce a Rule 35 report, there should be a process by which that individual is monitored and reassessed, so that if their condition changes, their level of vulnerability changes, that is picked up and they are routed back through a Rule 35 process again, and quite possibly would secure a Rule 35 report at a later date, and that should apply if that individual has a Rule 35 and is rated as a level 1, that should trigger again a process of review and monitoring, so that the IRC Healthcare can see whether that individual's level of vulnerability has changed. We don't see any of that process for returning to an individual and reassessing and monitoring to see if their level of vulnerability has changed. That's not built into the Rule 35 process.
So even where they have self-advocated and asked for a Rule 34 assessment leading to a Rule 35 report, contrary to the obligation under the rule, they are not routinely reassessed or monitored in any way to follow that process through. That
Not
doesn't
to my
form
knowledge.
part of the system.
Yeah, not to my knowledge.
What is your understanding of why there are delays in obtaining Rule 34 assessments or Rule 35 reports currently?
So my understanding is that it was a combination of a failure of earlier safeguards. So ideally, if the system worked, the detention gatekeeper would be picking up on vulnerabilities and grounds for routing someone away from detention before they even entered detention. Or at earlier stages. And because earlier safeguards are not working, there is a much greater reliance on the safeguards within detention.
So Rule 34 and Rule 35.
Yes, so that is effectively kind of the first in detention safeguard that someone would encounter.
And in your view, that's not working either in bringing to light vulnerabilities of detained persons who are victims of torture or otherwise at risk.
Yes, that's right.
Let's look then a little further at the case study. Alex, I think we're dealing with in number 1, when he was provided with a Rule 35 report in Harmondsworth, so not in Brook House, but afterwards when he was transferred to Harmondsworth, that indicated that he was a level 2 in terms of categorisation of evidence of torture. And again, so we're clear, level 2 indicates that there was some professional evidence that he was a victim of torture and it wasn't just a self-declaration from him. Is that right?
That's right, yeah.
The Home Office response was nevertheless that he would remain in detention. Is that right?
That's right.
The reasons the Home Office gave were that his immigration history clearly showed that he cannot be relied upon to comply with immigration requirements. Is that right?
That's right.
So is that an example of the balancing exercise that you referred to earlier, where immigration factors seem to outweigh the risk factors in relation to harm?
Yeah, that's right.
Prior to the adults at risk policy being brought in, and so the evidence levels approach that we've referred to, level 1 being a self-declaration, level 2 some evidence of from a professional of torture, and level 3 being also some evidence of likely harm, there was a category-based approach in place. And so if you fell as a detained person within a particular category, you were classed as an adult at risk. Is that right?
Yes, that's right. And there was a presumption that you wouldn't be detained except in exceptional circumstances.
So under the old category-based approach, immigration factors would not outweigh the presumption against detention except in exceptional circumstances. What effect does freedom from torture consider that the removal of reference to that high threshold has had on the presumption against detention for categories of vulnerable persons or adults at risk?
We think that this has significantly raised the evidential threshold at which someone can secure release from detention. It places a far greater emphasis on documentary evidence of vulnerability as opposed to self-declaration or indications that someone might fall within a category that has already been accepted as being at risk of harm in detention.
So the converse of that is it has effectively lowered the presumption. It's diluted the presumption against detention.
And it's enabled the Home Office to place significantly more weight onto the immigration factors at the expense of an understanding of the level of risk that's been described.
And so, in Freedom from Torture's experience, has that effectively raised the number of people with mental illness or significant issues in relation to past trauma in terms of being a victim of torture who remain in detention?
We can only assume so. We don't go into detention, so we can't sort of speak for the numbers that are survivors of torture within detention, but we can look at some of the statistics that have been produced, including the Home Office's own data on Rule 35 and releases on the back of Rule 35s, and also the data that the Independent Chief Inspector produces in relation to the functioning of the Rule 35 and what it means for the extent to which it provides a meaningful safeguard for vulnerable individuals, including torture survivors.
Yeah. In Alex's case, after his release, there was various clinical evidence available to you in the form of an independent psychiatric report, a letter from Freedom from Torture's own clinician, and a Freedom from Torture medico-legal report, all showing that detention had indeed had a negative effect upon him. Is that right?
That's right.
The report, that evidence, those reports don't distinguish between his detention at Brook House and Harmondsworth. Is that right?
That's right.
So it could be one or the other, or a combination of the two.
That's right.
So just dealing then with your conclusions as drawn from Alex's case, I believe at page 4 of your submission, what failures do you consider his case exemplifies?
So the fact that he was in detention for 42 days before he was given a Rule 35 report, I think demonstrates the failures of the healthcare screening process and the Rule 34 and Rule 35 processes. I think the fact that his MLR doctor found considerable evidence of torture, both in the form of lesions across his body, it should have been possible to identify some indicators that this man fell within a vulnerable category much earlier in his time in detention, had the effort been made by people who understood how to identify vulnerability and indicators of torture.
And given it seems that there was clinical evidence following his release that detention had caused him some harm, he had deteriorated in his mental health, would that have put him at level 3 in the risk evidence?
If that had been documented, if that had been written into his Rule 35 report, then it should have put him at level 3.
Thank you. Let's look then at case study 2, which starts at page 4 of your submission. This relates to an individual you refer to as Alan, again not his real name, who was detained at Brook House for 46 days from late February 2017 to mid-April 2017, so slightly before and into the early period of the relevant period with which this inquiry is concerned. While he was detained at Brook House, Alan did undergo a Rule 34 assessment that resulted in a Rule 35 report. Is that right?
That's right.
And the doctor concluded that he may be a victim of torture and does present with physical and apparent psychological evidence of this. Is that right?
That's right.
The doctor then concluded that since he was due for removal, it was unnecessary for the doctor to comment on the impact of ongoing detention. That's something that you've referred to before, that was often absent from the Rule 35 report. Is that right?
That's right.
And is that correct in your view? Should the doctor have declined to comment because he was due for removal?
No.
So the doctor should have filled that section in any event?
Yes.
The Home Office response accepted that there was level 2 evidence of torture, but again, in balancing the risk factors of continued detention against immigration control factors, the Home Office nevertheless determined, in common with Alex, that he should remain in detention.
Yes.
What does that indicate to you about the presumption against detention?
It shows how the Home Office is giving considerable weight, excessive weight to immigration factors when doing the balancing exercise, and relying very often on issues to do with compliance with reporting conditions, even when there has been a history of good compliance with reporting conditions from the same individual. They will still rely on that as a justification for not releasing, on the basis that that individual now has removal directions and therefore will not be compliant.
So even if they've been compliant in the past, if their removal is imminent, the presumption is made that they will now not comply.
Yes.
For level 3 risk evidence under the adults at risk policy to kick in, that requires additional specific evidence that detention is likely to cause harm. Here, the doctor had not commented upon that likelihood, as we've just discussed, and the Home Office relied upon that. So does that additional requirement make it much more difficult to secure the release of a vulnerable detained person?
Absolutely.
In Alan's case, from his freedom from torture clinician, he had, in a letter, identified exactly that risk to the Home Office prior to the issue of their response. That clinician had also told Brook House 3 days after his detention by writing to the duty medical officer, and had also written after a further 12 days, is that right?
Yeah, that's correct.
So both the detention centre, the immigration removal centre, and the Home Office had been informed that there was in fact evidence by a clinician of that level 3 risk, that detention was likely to cause harm.
Yes.
And the clinician stated that he was extremely concerned about the detrimental impact of Alan's continued detention was having on his mental health.
Yes.
Was any particular action taken by staff at Brook House as a result?
Not that we're aware.
What do you believe should have happened as a result of those letters, either by action by Brook House or by the Home Office?
I think the Rule 35 doctor should have taken into consideration the representations that were made by the FFT clinician regarding the level of vulnerability of the individual, the fact that they were a confirmed freedom from torture client in treatment with us, and that the clinician had raised concerns that detention was impacting on the anxiety of the individual, and so the risk of harm to which he was exposed. The doctor should have taken that into consideration when writing the Rule 35 report, and the Home Office should have taken those representations into consideration when they were doing the adults at risk assessment. Ideally, the Home Office should have sent the Rule 35 report back to the doctor to get that the missing information addressed, and then returned to the Home Office team so that they could make an effective decision on that individual's ongoing detention.
Yes. The current iteration of the adults at risk policy includes a section setting baseline requirements and standards for medico-legal reports and clinician letters from external bodies such as Freedom from Torture, which seems to set a higher benchmark for when they can be accepted as risk evidence. Are you familiar with that?
Yes, we were informed by the Home Office in August 2020 that they were considering introducing these quality standards for medical reports submitted as part of the adults at risk process. So we had a short period of engagement with them before the reforms that they planned were paused. Our engagement continued up until the point at which those medical standards were taken forward and put into the latest draft of the adults at risk guidance.
Does that concern you, particularly in the light of what happened in Alan's case, in that the Home Office didn't take into consideration Freedom from Torture's evidence submitted?
Yes, it concerns us hugely. I mean, these quality standards are specifically for reports that are commissioned by legal representatives to inform an adults at risk assessment. So in theory, they shouldn't apply to all medical evidence that is submitted for consideration as part of an adults at risk assessment. But what I think these quality standards show, or the desire to introduce them, is a level of suspicion around what they perceive as abuse of an essential safeguard for individuals, which is access to independent expert medical evidence of their vulnerability to inform an assessment of them. And what we see happening is, in response to, much as we saw back in the day with Rule 35 reports, whenever one safeguard gets excessive pressure placed on it, the Home Office becomes very anxious that that safeguard is being abused, rather than looking holistically at what else might be failing within the system that leads to an over-reliance on one part, on one safeguard within it. They sought to shut down access to it. And so from our perspective, the introduction of these quality standards was an attempt to raise the evidential threshold yet again, for access to medical evidence that could carry weight in an assessment, and an effort by the Home Office to apply less weight to medical evidence when it comes in from external experts, on the basis that it doesn't meet one or more of their quality standards, which, when you look across the 10 standards, some are quite reasonable and are probably being met quite easily by a lot of the report producers, but some of which are unreasonable expectations to place on a medical report writer.
Such as?
So, for example, they require that the writer must include consideration of the standard of care in the Immigration Removal Centre, including the standard of mental health care, and the expectation that every medical report writer has full and up-to-date understanding both of the medical care that should be provided, but more importantly, the medical care that actually is being provided within every IRC, is unrealistic.
Thank you. So at page 2 of your submissions, you effectively set out some overall conclusions that you've drawn from these 2 case studies under your heading Reflections and Recommendations. What were they?
So in summary, we think that the safeguards that are in place to prevent the detention of vulnerable individuals, and particularly torture survivors, are not working. And we think that includes everything from healthcare screening, so the induction and intake process, through Rule 34 assessments, Rule 35s, the adults at risk policy and process, the detention gatekeeper, all the way through to the final decision that's made by the caseworker of the Rule 35 team around continued detention. We believe these safeguards are failing.
And in your view, are these failings likely to be considerably more widespread than just in relation to these 2 individual case studies?
Yes, absolutely.
Let's look a little further then at the conclusions you draw from page 7 onwards in your submissions. You comment first on the Home Office's proposed reform of the adults at risk guidance in response to the Shaw report in July 2018. Is that right?
Yes.
Was there any other response from the Home Office to the Shaw report, to your knowledge, in relation to the adults at risk guidance? Have there been any changes implemented since Shaw to date?
So there have been a number of changes made. The proposed reforms that we became aware of in August 2020 was a package. So we talked about the MLR quality the medical report quality standards, which did have gone through and been implemented. Another part of the reforms that have been implemented involved bringing trafficking cases within the remit of the adults at risk process. That has also gone ahead. But other reforms that haven't been progressed concern changes to the adults at risk levels and changes to the Rule 35 process and scope. On the adults at risk levels, I can talk about those.
Firstly, pause there for a moment. Firstly, do you know why the reforms were paused in 2020?
So they were paused in anticipation of the new legislation. So the new plan for immigration was published in early 2021, and then the Nationality and Borders Bill followed, and the Home Office wanted to make the necessary legislative changes and then reform and adapt the adults at risk and Rule 35 process in line with that.
And so, to your understanding, are those reforms likely to be unpaused, as it were? Are they likely to continue
Yes.
from now.
Yes, I would expect so.
You say in your submission that Freedom from Torture are concerned about the direction of travel of these reforms. What do you understand the direction of travel to be?
We believe that the Home Office intends to further raise the evidential burden on individuals within the adults at risk process.
And the corresponding concern is that there will be a reduction in protection from harm for vulnerable individuals.
Yes.
Dealing then with the adults at risk levels, the 3 levels, so that we understand, level 1 is a self-declaration of being an adult at risk, including being a survivor or a victim of torture. Level 2 involves some professional evidence, either from a social worker, a medical practitioner, or an NGO, that the person is an individual, maybe someone at risk, including a victim of torture. Is that right?
Yes.
And level 3 involves not just that evidence involving the risk, but also professional evidence that detention would be likely to cause harm.
Yes.
Is that right?
Yeah.
Under the new policy then, the proposed policy, an individual would not be categorised as an adult at risk unless they had a professional assessment to support it. Is that right?
Yes.
So that would be what is currently level 2.
Yes.
Does that effectively do away with level 1, the self-declaration?
Yes.
Because at present, you're classed at level 1 evidence as an adult at risk if you simply say, I am an adult at risk for whatever reason.
Yes.
Just dealing with level 1 at present then, what is your experience as to how much weight the Home Office accords level 1 evidence, in other words, a self-declaration with nothing more?
Very, very little.
What is the problem with that?
The problem is that we've already discussed, I think, at length how difficult it can be for individuals to access the professional documentary evidence that's required to get them into a higher level, both because of their own vulnerability, which makes them least able to self-advocate for things like a Rule 35, or for a medico-legal report or other medical evidence from an external expert, but also because of the Home Office's best efforts to try and restrict access to those mechanisms. And also because there appears to be no mechanism built in to allow for a return to that individual for regular reassessment to see if their situation has changed. So once you have gone through a process and been categorised as level 1, it appears that you are sort
That's
of
the end
abandoned. Yes, you're left. That's your one bite at the cherry. So it's hugely problematic because, I think it creates an enormous risk that some of the most vulnerable people will not be being picked up by this safeguard and will remain in detention. Mm-hmm.
I think you mentioned earlier in your evidence that you think, as Freedom from Torture, that a self-declaration should in fact trigger an obligation on the Home Office or the detention centre, either healthcare or management, to inquire whether there is other evidence that the person is at risk. Is that right?
Yes.
And at present, there's no such obligation. As you said, there's one bite at the cherry. And having such an obligation would reflect the objective of protecting those who are particularly vulnerable.
Yes.
That deals with the level 1. Are those who previously have been assessed as having level 2 evidence also effectively being downgraded by the proposed reforms?
Yes, because it's placing a far greater emphasis on this prediction of harm within the assessment.
And if one doesn't have that, level 2 has effectively become level 1 and level 3 has become level 2.
Yes.
Is there a concern about a continuation of requiring a prediction of future harm in and of itself?
Yes, absolutely. In our opinion, it's incredibly difficult for an IRC healthcare doctor to predict the future harm of detention on an individual, and it effectively puts them in a position where they have to wait to see if there is harm before they're in a position to be able to say that harm and the risk of harm and a deterioration is likely to happen in detention. That is not preventative.
No, so it effectively requires the best way to predict future harm is if harm has already been caused, by which time the damage has been done.
Yes.
So, in other words, in your view, a past history of ill treatment in terms of torture or a past history of vulnerability and risk should be enough to trigger that higher level of evidence. One shouldn't require a prediction of future harm.
Yes, a category-based approach that's informed by significant evidence that people within a certain category can be presumed to be at risk of harm in detention.
And so the classification becomes automatic.
Yes.
And that's your view in relation to torture survivors.
Yes.
Is it also your view in relation to someone who has previously attempted suicide or has previously been assessed as a suicide risk?
I mean, that's going slightly outside the competency of, but I think the fact that someone has demonstrated indicators of serious distress, mental health issues to the level that they would self-harm or show evidence of suicidal ideation or attempts at suicide should be enough to indicate that that individual is highly vulnerable, and then further inquiries and efforts to document that vulnerability should be made.
Yes, and so the conclusion of freedom from torture, which was also Stephen Shaw's recommendation, was that a return to a category-based approach should happen.
Mm-hmm. Yes.
Moving on then specifically to Rule 35, and you've touched on this in various ways in your evidence, there is a planned expansion to the Rule 35 process to take account of all vulnerabilities, I think, and that's presumably a welcome change.
We do, yeah. We welcome the proposal to expand Rule 35 to cover all vulnerabilities, although I guess we would repeat our sort of persistent call for appropriate resourcing and training for the individuals who are responsible for identifying those indicators and documenting, so that they are in a position to do so without relying too heavily on individuals self-advocating and proactively seeking assessment under Rule 35 for all those vulnerabilities.
Is there also a concern to ensure that the existing separate functions of Rule 35, 1, 2 and 3 continue to operate? So 1 being that detention is likely to be injurious to health, 2 being whether there are suicidal intentions, and 3 being the victim from torture category.
We are concerned that the capacity to identify each of those categories and provide them with access to a protective safeguard under Rule 35 must be sustained.
So why is it important to have those 3 separate categories or functions of the rule?
Well, from our point of view, it's important that torture is recognised as a distinct category of vulnerability. We have extensive evidence within the literature and within our own with our own experience of working with torture survivors of the harmful impact of detention. And from our point of view, there needs to be within any protective safeguard an acceptance and understanding and a presumption that torture survivors are not suitable for immigration detention, except in the most exceptional circumstances.
Is it important to recognise the other 2 categories as well?
Yes.
Do you have concerns about the role of the clinician undertaking those assessments and the Rule 35 report? It's currently a GP. What are the concerns about a GP undertaking that role?
I think our concerns are less around the kind of level of qualification of the individual undertaking their role, and more around their skills, their training, their capabilities, and also the resourcing that's available to them, so the time they have and the environment in which those assessments are done. All of those factors should support an IRC healthcare professional to do the best Rule 35 assessment they can do, and to be applying the correct evidentiary threshold for it.
And so, in your view, it's important that the clinician carrying out the assessment and writing the report is clearly appropriately qualified and trained. Do you consider a GP to fulfil those requirements?
I think so. Yeah, I don't see that it needs to be someone of a higher level of qualification. The risk of raising any sort of qualification threshold for completing Rule 35 reports is that, again, it pushes the evidential threshold up further still. These, as I said earlier, the Rule 35 reports are not an MLR. It does not have to be completed to the standards of a medico-legal report. It doesn't have to be Istanbul Protocol compliant. This is a low threshold, and this is a safeguard that needs to be accessible. So I think putting the qualifications of the writer at a level that allows it to be accessible is important.
Would you have a concern if the level of qualification and experience or training was lower than a GP? Do you think it's important it remains a clinician as opposed to a nurse or a healthcare assistant?
I think we are more concerned about their ability, or the training and their skills and abilities in being able to identify and perform the tasks that the Rule 35 process itself requires. And as long as those requirements are met, then I think it could be a GP. I think there could potentially be the involvement of other healthcare professionals within the IRC.
Are you aware of a proposal that perhaps multidisciplinary panels could carry out Rule 35 assessments?
It's not something that I've looked into.
Would there be any concern about that? Would delay be a concern if more people were involved in the system?
Yes, I can see how that might be an issue. We're already struggling with access to the Rule 35 process, and resourcing being the issue that I keep coming back to.
Yes. It's important for the system not to be overly complicated.
Exactly.
You've also touched upon in your evidence that there doesn't appear to be built into the current system a reassessment or monitoring of detained persons after they're initially detained and subject to this process. Are assessments carried out frequently enough in your view?
So as I said, we don't go into detention, and our kind of level of knowledge of how the different processes work within the healthcare system within detention is limited. But my understanding is that, yes, they don't, reassessments and monitoring, particularly of vulnerability levels, does not happen consistently or systematically. The Home Office and the IRC healthcare teams don't seem to understand how vulnerability is dynamic and fluctuates and changes over time.
And so there also isn't assessment or monitoring of whether detention is in fact causing harm?
Not from what we can see.
Presumably you think detainees should be assessed regularly. Do you have any particular views on how regularly or how that could work?
I don't.
You have mentioned pre-detention screening. What are your concerns about how the current system of pre-detention screening works?
I'm not, to be honest, I'm not really aware of much by way of pre-detention screening.
In other words, it doesn't really exist.
Yes.
So greater effort should be made to identify those who are vulnerable, including torture survivors, prior to detaining them, in your view?
Yes, and the Home Office has piloted an enhanced screening tool, which was supposed to fill that gap, as far as I'm aware, and enable, I imagine, immigration enforcement staff at the point at which they identify someone for detention to conduct a very quick assessment and make recommendations on the back of that. But we were alerted to this tool very late in the day. We submitted comments to the Home Office as part of their evaluation. As far as we understand, the enhanced screening tool has also been paused. From our point of view, from our perspective, this enhanced screening tool was not a vulnerability screening tool as we would expect it to be. It was an extensive document with a wide range of questions, not just limited to assessing vulnerability and level of risk, but including questions around voluntary return and preferred airport of return.
So immigration factors,
yes,
as well as vulnerability assessment.
Yes.
You mentioned in your submissions the UNHR vulnerability screening tool. In a nutshell, what is that?
So this is a tool that is designed to help decision makers to understand the relevance of vulnerability to detention decision making, and it equips decision makers with guidance to help them in that assessment of vulnerability. And it talks about vulnerability domains, which probably is the closest thing we can find to the categories approach to understanding vulnerability. So torture falls into one of those domains, as we would expect it to, but there are other domains concerning things like gender and age that immediately flag to the decision maker that certain categories of individuals are presumed to be more vulnerable and at harm. It then equips them to make an assessment of the level of risk to which that individual is exposed, and provides guidance to the individual on placement options, as the UNHCR calls it, which basically means whether that individual goes into detention or some alternative to detention.
Yes, and your view is that the Home Office should be developing their own specific screening tool using the UNHR one as a guide.
Yes.
You make some key recommendations in your submissions, firstly at page 2, and you make 3 particular key recommendations. The first is that no asylum seekers or refused asylum seekers should be detained for administrative purposes. That would require a wholesale policy change that's outside the terms of reference of this inquiry. The second, though, is that the Home Office should ensure that all healthcare staff at IRCs are familiar with and use the Faculty of Forensic and Legal Medicine's quality standards for healthcare professionals working with victims of torture in detention. Again, just briefly in a nutshell, what do those standards seek to achieve?
So these standards aim to help healthcare professionals working in detention to identify torture survivors and to protect them from harm and to provide them with the appropriate treatment. And critically, they empower healthcare professionals working in detention to maintain their ethical obligations where those obligations come into conflict with the requirements of the authorities, so the Home Office in our case.
The third recommendation relates to the adult at risk framework that we've discussed. Should detention of asylum seekers continue, contrary to your first recommendation? And you say that the level 3 requirement for evidence that detention will likely cause harm should be reduced.
Yes. Yeah.
The Home Office should amend the adults at risk policy so that anyone with professional evidence of torture, including a Rule 35 report, should be designated as level 3, effectively.
Yes.
So doing away with the requirement for a risk of future harm or an assessment of such.
Yes.
And you say that the Home Office should effectively accord Rule 35 reports with their appropriate weight.
Yes.
On page 9 of your submission, you deal a little further with some detail of recommendations. You say in relation to pre-detention screening, and we've touched on it just now, that in your view the Home Office should develop a mechanism for identifying vulnerability prior to detention, and that's the screening tool we've just discussed.
Yes, it could be in the form of a screening tool that's used, for example, at the point of contact in enforcement action, although with enormous caveats around the environment in which someone extremely vulnerable finds themselves at the point at which they are identified by enforcement action, not being a very suitable environment in which disclosure of vulnerability can happen.
Yes.
Nonetheless, I think it's important to equip immigration staff across Home Office's functions with the ability to identify indicators of vulnerability. Other parts of the system could be enhanced to do a better job of identifying vulnerability. For example, the screening process that asylum seekers go through when they first enter the asylum process.
And you also say that the evidentiary threshold to indicate risk must be low enough that someone at risk is unlikely to enter detention.
Absolutely.
So it's about the threshold of that risk as well as the identification of it.
Yes, it needs to be a preventive safeguard.
You have mentioned a number of times that those who are responsible for identifying vulnerability should be adequately trained. What sort of training do you think is necessary?
So we're not really aware. We haven't been provided with the training materials that the Home Office is using to train its staff in vulnerability, but we have had them described to us and explained to us at great length and been reassured that they are quite capable of equipping their staff with the skills and tools they need. It's hard to say, therefore, what the gap is between the level of training that's currently provided and the level that it needs to be at. But I would say, at the very least, it should be capable of giving all of their staff, at least all of their staff who come into contact with individuals from the very first point of contact with immigration process, but all the way through to those who have no direct contact with individuals but are making critical decisions around the routing of that case into detention or elsewhere through the process, have a good and consistent understanding of what vulnerability is and what the indicators of vulnerability are and how to feel confident that the process that they have gone through is sufficient to be able to make good decisions around routing of those vulnerable individuals.
Yes. Again, you've mentioned that there should be more regular assessment and monitoring of the welfare and well-being of those at risk. Is that once they're in detention?
Yes.
And who do you consider would be best placed to do that monitoring and assessment?
I think the healthcare team within the Immigration Removal Centre is really the best placed entity to be doing an assessment of ongoing healthcare needs, mental health care needs, and vulnerability associated with those needs. But critically, other third parties will be having contact with that individual, their legal representative, any wider support network, organisations like Freedom from Torture, where we are able to sustain contact with that individual. We will be forming opinions of the level of vulnerability and deterioration in their mental health. Any representations, we should be invited to make representations, and any representations we make should be taken into consideration alongside any input that the IRC healthcare team are able to give.
Yes. And are there any other recommendations which you consider to be particularly important that we haven't already covered? We've talked about the key decision makers taking into consideration the full range of evidence available to them, and I think that's really important in the context of the detention gatekeeper, which, from what we're aware of, is making a paper-based assessment of someone's appropriateness for detention. Beyond that, we think it is essential for those individuals to have some form of direct contact with the individual that they are making a decision about. It shouldn't be purely a paper-based exercise. The person who is making such a serious and important decision about exposing someone to the harm of detention should have some face-to-face direct contact with the individual concerned. And I think I've talked about the resourcing that needs to go into the system. This is critical around Rule 35. People need to be able to access them quickly. The process needs to happen. There needs to be a quick turnaround in terms of Home Office response, and we need to address the gaps within the documentation that's produced and the quality of the documentation that's produced in the Rule 35 process. Yes. And critically, allowing or enabling detainees to be aware of the safeguards that are available to them, and this should be happening at the point of induction. They should be in a way that is sensitive to their ability to intake information at that point. They should be made aware of the Adults at Risk Rule 35 processes and the safeguards available to them, because while the system continues as it is now, there is a responsibility on them to self-advocate
So they must be made aware of the safeguards that are available.
And that should be at induction, but should it also be thereafter as well?
Yes.
Thank you very much. Chair, those are all the questions I have for Ms Reynolds. Do you have any questions for her?
Thank you. Yes, just one brief. Thank you, Ms Reynolds. In terms of you talked about the process and keeping the detained person informed and able to access the safeguards. Do you have any views about the need to inform the detainee of the result of a Rule 35 report that has been completed?
Yeah, I mean, I think detainees should be kept up to date with all developments in their case. I think communication with a detainee is critical, both to a sort of a successful and efficient processing of their claim, but also to their health and well-being. I think one of the most damaging impacts of detention is the lack of communication and the sense of uncertainty and not knowing what is happening with your case and how it's progressing and what the prospect is of you ever being released from detention. That is extremely harmful to an individual. So I think it is really important that if they have gone through a process like a Rule 35, which they will have been aware of at the time, that they be given information about how that case has been resolved.
Thank you. No more questions for me. Thank you very much, Ms Reynolds.
Thank you. Chair, I'm conscious of the time. We're finished with this witness. This might be an appropriate moment for the break, maybe slightly earlier than intended. And so if you're agreeable, I suggest 15 minutes and we'll start with the next witness after that, who will be Dominic Aitken.
Oh, great. Thank you very much. So we'll return at 11 o'clock. Thank you very much for giving your evidence. I know it isn't necessarily an easy experience, but I very much appreciated it.
Thanks so much.
See you at 11 o'clock. Thank you.
All right.
Thank you very much.
Repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Please sit down.
Chair, we'll now be hearing from Dominic Aitken.
Thank you, Ms Moore.
Good morning, Dr. Aitken. Could you confirm your full name to the inquiry?
My name's Dominic Edward Aitken.
And we have a witness statement to the inquiry, signed and dated 25th of November 2021. That's at INQ 000094. Chair, it's your tab 1.
Thank you.
Can you confirm that that's your statement?
Yes, that's mine.
Chair, I will ask for this statement to be adduced in full. Dr. Aitken, that means that we're not going to go through everything in your statement. That's already in evidence for you. But there are some topics that the inquiry would like to hear more from you on. You were also interviewed by Verita on the 8th of January 2018, and you've had the chance to look over it again and confirmed in your statement that, in general, that account is still accurate. And I will ask for the transcript of that interview to be adduced too. That's a VER 000257. That's your tab 3, Chair.
Thank you.
And if I refer to that, I'll just call it your Verita interview. So you came to be in Brook House due to your academic research. At the time, you were doing your DPhil or PhD. And in brief, what was your topic or your title?
My research was about how places of custody, primarily prisons and immigration removal centres, how they deal with people who are at risk of suicides, whether that is self-harming, attempting suicide or completing suicide. And I did some empirical research in Brook House, and I interviewed a number of professionals who do death investigations.
And you were at Brook House for about a month?
That's correct.
Was that 3 to 5 days a week?
Yes.
Particularly while you were at Brook House, what was the focus of your research while you were there?
One of the things that I really wanted to understand was how efforts to keep detainees safe and how efforts to manage risk fitted into the broader institutional context of running a secure environment like an immigration removal centre. So I wanted to understand not only how members of staff dealt with detainees who had been identified as being at risk of self-harm or suicide, but also to understand how that fitted into their broader working patterns.
And you describe your access around the centre as relatively unrestricted. You had, I think, a set of keys.
Yeah, that's correct.
Was there anywhere you weren't allowed to go?
To the best of my knowledge, I was allowed to go pretty much everywhere. I spent the vast majority of my time on the residential units, in the recreational facilities and in courtyards and staff offices and so on. But I was given, for an outside researcher, I was given quite a lot of freedom, I thought, to go around the centre.
Was there anywhere you could only go if you were accompanied?
I'm not sure, but overwhelmingly I went around on my own.
And you did spend some time on E-Wing?
Yes, that's correct.
What about in the care and separation unit, the CSU?
I spent a little bit of time in there, although I was usually in there for some specific reason. So in one case, I was interviewing a member of staff who was working in the care and separation unit, the segregation unit.
And did people know where you were when you were around? Did staff know where you would be?
In the main, no, I didn't really need to explain myself to anyone. I didn't need to sort of report to anyone during the time that I was there. There were some days when I would shadow a particular member of staff, so it's quite likely that I would have been with them most of the time. But I was given quite a lot of autonomy, so I was free to kind of go around and go wherever I wanted to go.
And how were you introduced to staff on your first day or two? What did they know about your presence?
I think some members of staff had probably been briefed at a morning meeting that I would be there, although I think a lot of people weren't really aware of my presence until they actually saw me in person and I went up and introduced myself, or they would see me around a wing speaking to detainees or other members of staff. So I would usually go and introduce myself and explain who I was the first time I saw anyone.
Did you have an ID card or a picture name on anything?
I did, yeah. I had a sort of G4S issued lanyard with my face and name on it.
In relation to information gathering, you discuss at some length in the statement your methods of evidence gathering. That's at paragraphs 20 to 21 and 23, which you say was qualitative and not quantitative. So it was immersive and based on interviews rather than data-driven.
Yes, that's correct.
And you also recognise that your research wouldn't be called typical ethnographic research because rather than doing a long-term immersive project, you were there for a relatively short time.
Yes, that's right.
So you got a snapshot, but not an in-depth over a long duration.
Yeah.
And you also did a series of interviews, I think 18 interviews with 19 people.
Yes, that's correct. So the vast majority of them were one-to-one interviews, but one of the final ones that I did was with 2 members of staff. So 19 participants, but 18 interviews.
And the people who you interviewed, did they know the purpose of your research?
Yes, so they had to fill in a kind of consent form, which included information about the research I was carrying out.
And they knew that you were taking notes or recording the interviews?
Yes.
Can I ask you about your first day at Brook House? So you witnessed an incident that you describe in the statement of paragraphs 24 to 25, which you say you witnessed a man, and we'll refer to him as D401, on E-Wing, and you say that he was detoxing. In your statement, you say, it was clear that he needed help, but custodial staff were obviously ill-equipped to deal with such a serious issue, which would have required medical and other expertise. Did you know whether he got help from medical or other staff during this episode?
I can't recall whether or not he got medical help when I was there. I'm fairly sure that the staff would have been trying to achieve that, but I can't recall whether or not he got medical attention at the time that I was there.
In a blog post that you wrote, which I won't take you to because you'll remember it, and it's in the evidence chair, it's at tab 2.
Thank you.
You mention this incident and you say, I saw staff deal with a severely ill man who was detoxing, who they knew should not have been in detention. That's the same event?
Yes.
On the first day. And did the staff looking after him tell you that he should not be in detention?
I think it was, if not made explicit, it was very clear that they thought they were not equipped to deal with him and that he was very, very poorly. I say that I'm not a medical expert, but I think it was fairly plain that he was very unwell.
I want to ask you about staff's perceptions of other members of staff, which you deal with in your statement. For example, at paragraph 41, you ask questions, what makes a good member of staff and what makes a bad member of staff to many of the people you interviewed. Did you ask detained people or just staff members about this?
I just asked staff members, and this was during the formal interviews with staff members.
And in general, what impression did you get of how those at Brook House saw a good member of staff?
Primarily, when they were speaking about what a good member of staff was, they emphasised a number of important interpersonal skills, so the ability to communicate effectively, working hard as part of a team, somebody who did the right thing, who was conscientious. So they stressed a number of interpersonal skills, but they also emphasised the importance of being vigilant, of not being naive, of being cognizant of the fact that it's a secure environment, but at the same time kind of balancing security concerns with welfare concerns. I think that was the kind of thrust of what members of staff said made a good member of staff.
And if you're able to recall, were these qualities such as the interpersonal skills things that they thought could be or had been received during training, or that they were more of a natural skill?
I think it was probably a combination of both. Many staff members said that some people, especially early on when they first came into the job, couldn't really handle it. So they would often have people who were only employed for a short period of time when they realised how difficult an environment it was to work in. So it would be emphasised in training, but also in everyday actions and also through their sort of socialisation. The idea was you always want to resolve things with your voice as much as possible.
What about when you asked them what makes a bad member of staff? What sort of things were you told then?
I suppose there were lots of things that people mentioned that could make a bad member of staff. One of the things was somebody who was lazy, who didn't work as part of a team, so the inverse of all the positive qualities that I mentioned earlier. One thing that a number of staff alluded to, I mean, it was somewhat vague, but they said members of staff who were in the job for the wrong reasons. And they would usually either explicitly say or suggest that what they meant by that was people who were attracted to the sort of power and authority of the role. So the fact that they wore a uniform, wore boots, carried keys and a radio, and were authorised under certain circumstances to use control and restraint, so to physically coerce people. And there was always a suggestion, any members of staff who mentioned that to me would never say that they themselves were like that, nor that, you know, colleagues that they associated with were like that, but they sometimes would refer to there are some members of staff who are attracted to that aspect of the role. So they would usually say that they were in the job for the wrong reasons.
And did you get an idea of what level of staff they were discussing? Was it DCO, DCM, senior, healthcare level?
I think it would primarily be speaking about DCOs, so the detainee custody officers, so those who are on the ground and dealing with detainees on a sort of interpersonal level from day to day, and also who might be called upon during, for example, a planned removal or unlocking somebody from a room or cell. So it would primarily be the kind of lower grade members of staff like DCOs.
I want to ask you about staffing levels. You mentioned at paragraph 51, as you did when you were interviewed by Verita, that some DCOs said staffing could be a problem and that even with 4 DCOs on a wing, if they all had individual tasks, in reality it was one person looking after the wing. Did you personally see any effects of understaffing or get the impression that DCOs were under this sort of pressure?
I certainly recall a couple of occasions where I would see maybe 1 or 2 members of staff on a wing which was notionally staffed by, say, 3 or 4 people. So it may be that another member of staff was escorting someone elsewhere in the centre, or they were going on being taken outside of the centre, or they had to go to do a constant watch, meaning that they constantly have to stay with an individual detainee. So I certainly saw some occasions where there was maybe 1 or only 2 members of staff on a wing with maybe 100 people on it.
And for a short period of time, for minutes or hours or a whole shift?
I can't say for sure how long it would have been. When I was observing it, it might have been relatively brief, so maybe for half an hour or something like that. But I was certainly told by members of staff that there could be periods where it would be longer than that.
And did they discuss with you the sorts of difficulties or issues that could arise when they were left on their own for such periods?
They were generally aware, as staff were at all times, that at any given moment things could kick off and things could suddenly go wrong very quickly. So they would be concerned that, for example, if they found someone who was attempting suicide, or if a fight broke out, or somebody had overdosed on drugs or something like that, if they were alone as a member of staff, they would really struggle to cope with that. Because they would then need to attend to an individual person or a small number of people, but that would then leave the remainder of the wing unattended. So I think those would be the kind of situations they would have in mind.
And did you personally see any circumstances where somebody's time pressure meant that somebody had to effectively leave a wing unattended?
I don't think I ever saw that, no.
Can I ask what your impression, if any, was of Home Office presence on site? Did you see members, representatives of the Home Office at Brook House?
I think I saw them very occasionally, but ordinarily no.
And did you speak to staff or to detained persons about Home Office presence on the site?
When I had informal conversations with detainees in the first couple of weeks that I was there, many of them spoke in fairly general terms about their unhappiness about lots of things to do with the Home Office. I didn't specifically discuss with them their presence on site. Some staff members did allude to the fact that Home Office caseworkers were located off-site and that created a number of problems for them.
What sort of problems?
It meant that the members of staff who dealt with detainees on a daily basis didn't really know a great deal about their case. They were often having to relay bad news to detainees, and so sort of clearing up a mess that had been made by someone else outside of the centre. And it also meant that a lot of key information was just not shared. So staff were uncertain about lots of things, detainees were uncertain about lots of things, and unsurprisingly, there was a lot of frustration about that.
And what sort of things? Uncertain about what sort of things?
So the duration of detention, any prospect of release or removal. For instance, if there had been things like a flight might have been cancelled or something like that. All of these things would cause a great deal of frustration, obviously, particularly to detained people.
And you say the Home Office staff were not on site. Do you mean they were in a different part of the building away from the residential or shared areas, or they were completely in a different place?
They were more or less completely in a different place. You would sometimes see individual caseworkers coming because they might have a specific meeting, or they might be going to meet managers or senior managers, but in the main, on the kind of daily basis, I don't recall seeing very many Home Office personnel.
Did you see any visitors from the Independent Monitoring Board, the IMB, while you were at Brook House?
I can't remember if I did, because I've spent some time in some other IRCs and I've spoken to people from the Independent Monitoring Board there. I'm not sure if I'm remembering the Brook House IMB or a different IMB, so I can't remember.
Fine. And what about the Gatwick Detainee Welfare Group, GDWG?
I don't think I met any of them personally, no.
Do you remember if you spoke to any of the staff about any of the kind of monitoring or visiting bodies?
As in, did I speak to Brook House
Yes.
staff? I think occasionally members of staff would mention oversight bodies, and I think typically, from recollection, when staff spoke about them, their impression was that oversight bodies were very sympathetic to detainees and were perhaps not very understanding of how difficult their working lives were. But that was fairly brief when I had conversations with staff about that.
And just to be clear, I think I ran the two together. You said that they were overly, the impression was perhaps from the few that you spoke to, they were overly sympathetic to detainees. And I had mentioned both the IMB and Gatwick Detainee Welfare Group. Do you remember which, if either of those two you're referring to?
It probably would have been the Gatwick Welfare Group, but I think it's fair to say they might have been lumped together.
Thank you. I'm going to ask about the staff's perception of the detained population now. So you spoke to staff about the residents of Brook House, of course. Can you tell us about your impression of how staff saw the residents? So first, you mentioned at paragraph 26, the staff's impression of people who had been there for a very long time. Did you get the sense that the long-term residents were treated differently in any way from other residents?
I'm not sure about them being treated differently, and that wasn't something that I necessarily observed. But I would say that members of staff, if they knew how long someone had been detained for, would often mention that to me or would identify a particular individual who they said had been detained for a long time, and would often express their sympathy for the fact that somebody had been detained for a very long time.
And what particular views did they express about either the length of detention or the fact of these people who'd been there for a long time? You say they express their sympathy about them.
Yes, I think they for people who had been detained for a long time, and I mean people who'd been detained for maybe a year or more, which was a relatively small number of detainees, a handful of them at any given time. But they would typically say that they thought that that was unfair, and that if the Home Office or the government was unable to remove somebody or deport somebody within a more reasonable time frame, that it didn't really seem fair to keep them in detention for such a prolonged and uncertain duration.
And did you get the impression this caused any difficulty with the way these people were dealt with, or that they had to be approached in a different way to other residents, or it was just an impression they expressed to you?
There were some individual detainees who I knew had been detained for a long time, and whose behaviour was undoubtedly quite difficult for staff to deal with, because they were acutely frustrated and angry about how long it was taking for them to be released or removed, and there didn't seem to be very much progress on their case. So there were some cases where that was manifest in the behaviour of the detained people.
And you mentioned also detainees who'd been perhaps raised in Britain or who'd lived in Britain for a long time prior to their detention. What did staff say to you about that group of people?
When staff spoke about people who had been living in Britain for a very long time, so for example, if their family had come from, say, Jamaica when they were 3 or 4 years old, staff would often say that they are, to all intents and purposes, British because they went to school here, they might have gone to college or university or worked here, all of their family and social connections are here, and often there were certain cultural markers, like they spoke with, for example, a London accent, and this would strongly suggest that they are, to all intents and purposes, British, even though they might have been born overseas. So staff, again, in some of those cases would sometimes express sympathy with those particular detainees.
You also discussed with staff the men at Brook House who had served prison sentences and who were being held at Brook House prior to their removal. We've called them time-served foreign national offenders. Can you tell us, and you discuss it at 68 to 69 of your statement, what staff's views were of this cohort of the detained population?
So Brook House was regarded informally as a higher security IRC, even though it doesn't have a sort of formal security classification like you have in the prison estate. But staff were aware of the fact that I think Brook House had maybe a slightly larger proportion of ex-foreign national offenders in their population than other centres, maybe similar to somewhere like Colnbrook at Heathrow. And so, although it was less than half of the detainee staff were very aware of the fact that quite a lot of the detainees were ex-prisoners. And so I think that coloured their perception not just of the ex-prisoners, but perhaps of the whole detention population, which was that they needed to be very vigilant. They needed to be aware that people might be trying to manipulate them. The term that they used was to condition members of staff, so to kind of slowly manipulate them over time. And it meant that they needed to be vigilant at all times. I think that was the effect of having so many ex-prisoners.
You just referred to the term conditioning as well as manipulation. So conditioning is a term that staff use to you, is it?
Yes, I heard quite a few members of staff talk about the risks of being conditioned by detainees.
And if you're able to say, was this something that you felt they'd received sort of training on, or was it more of an informal use of the term?
I'm unsure if it would have been mentioned in training, but it was something that informally and through their sort of first-hand practical experience, they were very aware of and they mentioned to me.
And just to reiterate, what did you understand them to be concerned about when they talked about the risk of conditioning or attempted conditioning?
Essentially, the idea was because you spend a lot of time with detained people, they are living in this environment and you're working there for perhaps 12 hours a day. You spend a lot of time with them so you can potentially get to know them quite well, and you have to form interpersonal relationships with them of some kind. And so one of the risks of that, members of staff claimed, was that some detainees would try to manipulate members of staff. They often said to me that it would be impressionable members of staff, often younger members of staff, often women. And they would be to try to get, the idea was that detainees would be trying to get favourable treatment by influencing a member of staff over a prolonged period of time. That was the idea of conditioning. I'm not saying that it was a valid concept necessarily, but that was what they said.
And did anyone say that this had happened to them, or anyone had tried to do it to them, or was this something that happened to other people?
Always happens to other people.
Paragraphs 43 to 44, you talk about staff's treatment and approaches to men of different nationalities in relation to use of force in those paragraphs. In summary, you say staff would say it's all down to the individual, that's what they'd report to you, and that residents are not treated differently on the grounds of nationality, religion, race, but that in reality, particularly when they spoke to you about control and restraint, that did not seem to be the case. How did that manifest it? How did you get that impression?
So I had some members of staff explicitly say to me that in certain circumstances they would send staff of a particular sex or gender and particular race or particular age knowing information about a detainee. So the perception among some members of staff was that, for example, Caribbean men or Afro-Caribbean men were regarded as being chivalrous, and therefore they would be more respectful of women. And so if you were going to do a planned removal, you might want to have more women involved in the planned removal. Or similarly, if you were going to do an ACDT review, so an assessment, care and detention and teamwork at risk for suicide review, you might want to have women do that rather than men. By contrast, the perception was, I think this was sometimes explicitly stated to me, that Arabic or Muslim men were sexist or were disrespectful of females, was the phrase that I'm sure a number of staff said. And so in those circumstances, you might want to have men do a planned removal or an unlock from someone's cell or an ACDT review or something like that.
Was your perception that this would be arranged informally, so it wouldn't be clear to somebody perhaps looking at the documents that that decision had been made on the basis of a presumption about somebody's race or background?
Yes, that's correct. I should say that probably wasn't the only consideration about who they would have doing it, but that was certainly one of the things they might think about.
And did you see any evidence of that yourself when you, for example, saw teams who'd been dispatched to deal with one thing or another?
I didn't observe it myself, but as I say, I think some members of staff mentioned it to me either in interviews or informally during conversation.
Did you witness any control or and restraint at all while you were there?
I witnessed certainly one control and restraint, but it was very brief. I was having a conversation with a detainee on E-wing, another detainee who I think was might have had a recognised mental illness. He threw a little bit of food at one or both of us, and then the man who I was speaking to reacted by going up and sort of slapping him. And a member of staff came and restrained him, but it was, so I had to fill out a security report. I can't remember what the official name for that report is. I certainly saw that use of force, but that was a relatively unproblematic and brief one. I can't recall seeing another use of force.
And not a planned use of force.
And not a planned use of force, no.
Did you observe any of the meetings prior to planning a use of force, so the briefing or debriefing, in fact, meetings?
On my first or second day, quite early on, I attended a meeting for managers about a charter flight that was due for that night. And so they were making lots of preparations about how they were going to get quite a large number of detainees. It might have been as many as, it might have been more than 20, some of whom would be arriving into Brook House that night, many of whom were already in Brook House. So there were kind of preparations for how they would do, how they would kind of orchestrate the situation to get people into various parts of the centre that would make it easier to do the planned removal and the charter flight. So I did attend a meeting which was preparations for a charter flight.
On to managing the behaviour of the detained population, and this is something you mention at paragraph 54 of your statement. You say that some staff felt that incentives and privileges should be introduced, which would be similar to those in place in the prison system. The staff who mentioned this as an idea, or presumably you asked them about what could be changed, were they staff who had worked in the prison system generally?
Usually, no. So the people who desired greater formal or structured incentives and earned privileges system like they have in the prison estate, quite often they were staff who themselves hadn't worked in a prison. And indeed, the staff who I spoke to who had worked in prison typically said that IEP was not the kind of silver bullet solution that some people might think, because it's more complicated than that and there are other factors at play.
Okay. Can you tell us what IEP stands for?
Sorry, incentives and earned privileges.
And why did the staff who say that would be a good idea seem to favour that as an approach? What did they think the benefits would be?
What they said to me was that they lacked disciplinary tools to deal with bad behaviour in the centre. Sometimes they would say that in the sort of good old days when Brook House first opened, so around 2010, there was perhaps a slightly more disciplinarian staff culture that had been criticised by Her Majesty's Inspectorate of Prisons, among other people. But some staff said that, we used to be able to do this and now we're not able to. So it was specifically to punish bad behaviour, though I should say that in principle, incentives and earned privileges is both about rewarding good behaviour as well as punishing bad behaviour. But it was always punishing bad behaviour that people were interested in.
Did they generally speak about punishing bad behaviour, or did they give examples of the sorts of behaviours that would be liable to be punished?
They would usually speak in fairly general terms about punishing bad behaviour, but they might have had specific examples in mind. For instance, people, if they were verbally abusive to members of staff or to other detainees, if they were being kind of generally difficult to manage, but then also more serious things like drug taking or drug dealing or violence or things like that.
And for those of us who don't have any experience within the prison system or know of IEPs, what sort of benefits or detriments might be offered out to punish or to discourage such behaviours or to encourage good behaviour?
So I don't know a massive amount about this, but if you were on a kind of, I think it's called enhanced level in the prison estate, that would mean that you might have access to, I don't know if you might have access to a slightly nicer room, but you also might have greater access to things like television. You might be permitted more visits, a number of kind of things like that. Don't quote me on that because that might not be exactly right. But the crucial thing and what would be relevant here is that if you went to the basic level, so rather than the kind of standard level that you would enter prison at, if you went on to basic level, you would have certain privileges removed from you. So basically, certain goods and services that you might want would be stripped from you, or they would be harder to access, or you could access them less frequently.
Things like access to the shop, or?
I think things like that, though I'm not 100% sure.
And that's not because the people you spoke to didn't give specific examples of the sorts of privileges they'd want to take away, or you can't remember if they did?
I can't remember if they specified particular privileges that they would want taken away, but they generally thought that they didn't have adequate disciplinary tools.
Thank you. You say about paragraph 55 that an art teacher you spoke to, Sarah Walpole, had the impression that even though she was not a DCO, she had to be vigilant, wary and distrustful of detainees. Do you know how she got that impression? Is it something she developed over time while at Brook House, or?
In this case, she mentioned to me that it was something that had been instilled in her during her training. And she said that her impression from the training was that the overall sort of message that was sent, this wouldn't have been stated explicitly, but her impression was to think of detainees as an enemy or a kind of us and them mentality.
And did other people you spoke to have that similar, give that similar impression to you, that they saw detainees as the enemy, or saw an us and them approach was appropriate?
I certainly saw plenty of members of staff who spoke about detainees in a way that suggested that they were suspicious of them, that they were distrustful of them, or that they always needed to be aware of the possibility that they might be being misled or being manipulated. Yes, I certainly saw that.
And when you saw interactions between staff and detainees, did you perceive that same us and them attitude?
Not necessarily during interpersonal interactions, the vast majority of which were perfectly kind of civil and respectful. So in the main, no, not from the kind of everyday interactions that I saw.
And from paragraphs 59 to 61, you summarise there your belief about staff's perception of violence. And in summary, and correct me if my summary is wrong, you say that even infrequent violent incidents, riots, protests, etc., will tend to stick in the mind of the person who sees them more than your day-to-day occurrence.
Yes, that was certainly the perception that I had speaking to members of staff, is that even though there had been a riot in the early days at Brook House, which some members of staff did work there at the time and were still employed there, but many members of staff weren't there. But knowing that there had been a riot at Brook House and at other detention centres, or knowing that there were occasionally episodes of violence, they were very aware of that possibility, even if in reality, on a day-to-day basis, it was relatively infrequent.
Did they speak to you about events like that at other detention centres then?
I can't recall if they mentioned events like that at other detention centres, no.
And from what you were told, what was the effect of this knowledge or this memory on the way that staff perceive current levels of risk?
I think generally it contributed to a kind of heightened suspicion or vigilance about the entire detainee population. I remember one member of staff saying to me, things can go wrong here very quickly, and that laconic observation captured what a lot of staff felt.
So you said to Verita in a similar way, there was a constant motif around how it could all kick off and suddenly the place would be up in flames.
Yes.
But you added, when you spoke to Verita, in some ways my sense was that the biggest risks that they faced had nothing to do with that. The biggest risk that they faced would be that someone would kill themselves.
Yes, so I suppose I would maybe add to that that the bigger risks were all of these different risks that were being stored up every day. So you have lots of different vulnerable people coming in that you don't necessarily know a great deal about, or you're not very sure that you're equipped to treat them. And so that might end up with somebody ending their life or attempting to end their life, or any number of other serious risks that you were storing up on a day-to-day basis.
And when you mentioned that that's the biggest risk, or one of the biggest risks, is that your view that that was one of the biggest risks, or did you perceive that staff saw the possibility of someone killing themselves as a big risk as well?
Yeah, I thought that was certainly my own perception, but I think it was shared by members of staff. They were aware of the possibility that somebody might die while held in Brook House, and in some cases they had dealt with so-called near misses, where someone had very nearly died in custody. Or they had worked at other detention centres or other prisons where people had died when they were working there.
And the people who had such experiences, did that change the way, in your view, they saw risk or the nature of risk they were likely to be faced with?
I think in plenty of cases, yes, it would have made them very aware of it, and that would be something that they would try to impress upon their colleagues, how serious that was. Yeah.
And you mention at paragraph 73 that DCOs have to deal with consequences of issues outside of their control, such as health problems or decisions around deportation. And you add that DCOs are aware of their responsibility to avoid major events, such as escapes, riots, a death in custody, or other low-frequency, high-impact problems. When you mention that they're aware of their responsibility, do you mean a moral responsibility, a legal responsibility, a contractual employment responsibility?
Probably all of the above. I think with respect to the risk that somebody might die in custody, staff would have probably been aware of a kind of vague sense of legal responsibility, though they might not know exactly what a coroner's inquest would entail, or any other kind of formal legal process. But they would probably have been aware of a general sense of legal responsibility, but also a professional responsibility, and also, I'm sure in many cases, a moral responsibility too.
onto then the focus of your research specifically, which is self-harm and suicide, and what you were looking at while you were at Brook House. In terms of staff's understanding of the risk of these events, at paragraph 33 of your statement, you say in summary that staff generally took self-harm and suicidal behaviour seriously. You mentioned the ACDT process, as well as frequency of observations, speaking with detained people and listening to them as actions around these risks. And when you discuss there that lengths that staff would go to assist people in crisis, is that something that people described to you, the lengths they'd go to, or did you also observe staffs going to lengths to help people in crisis?
I think I probably did observe one or two cases where staff were spending an awful lot of time with someone. It may not have been during a formal ACDT process, but someone who was on an open ACDT form and would be spending an awful lot of time with them, patiently discussing their problems and trying to calm them down and trying to reassure them in various ways. So I occasionally would have directly seen it, but it also would have been, staff would have spoken to me about how long they would often spend with at-risk detainees.
And are you able to tell us who undertook ACDT observations? So when there was a formal process in place for somebody to be observed at whatever intervals, was it detention staff, was it healthcare, was it a mixture?
Primarily in the cases that I saw, it would have been detention staff who would have been doing the observations, but when there was, so if there were, for example, hourly observations, you would have had a detainee custody officer, a DCO, working on the wing, I think would write down various notes in a bright orange booklet. And then when there was a more formal review, that would need to be a manager or a kind of qualified assessor. I think healthcare staff would be there. And you also might have somebody from the chaplaincy, for example, so you might have an imam or a priest or something like that, or any other member of staff who might be relevant.
And when somebody was on those observations, from what you saw or what you were told about, what was the nature of the observations? Was it looking and recording or verbal engagement or a mixture?
It would be a mixture of both. In principle, or ideally, you would obviously want both physical observations or observations about someone's demeanour, but you would also want things that you had actually directly spoken to them about. In some cases, somebody might, for instance, have been asleep during an observation, so there's obviously a relatively limited amount you can say. But ideally, it was supposed to be both. Some members of staff would say to me that sometimes the notes that they received weren't very detailed, or they wished that their colleagues would ask more questions or go into greater detail.
And by notes they received, do you mean when the handover of one person taking care of somebody on an ACDT was handed over to another?
Yeah.
And they would read those notes to get an idea of what happened?
Yeah.
And when they said that they weren't very detailed, did they say were they able to do anything, speak to the person, ask them to make more detailed notes, or was it just a general gripe?
That was more a general gripe that I heard a couple of members of staff say, that they sometimes weren't as detailed as they would like them to be.
And you discussed the role of healthcare in ACDT, which you think was perhaps when there was a more formal review rather than on the regular observations. Mm-hmm. In general terms, did you form a view of whether healthcare and detention staff work together well or closely to manage vulnerable people?
My impression was that they didn't work especially closely. I should say that I didn't spend very much time speaking with healthcare staff. I spent a little bit of time in the kind of healthcare unit or speaking to individual members of staff, but the vast majority of time when I was with staff members, it was with custodial staff. But my impression from both DCOs and then also from managers or people kind of higher up the chain was that they felt they would benefit from more leadership from the healthcare team, perhaps more information about signs that they should be looking out for or symptoms that they should be aware of for particular conditions, and then occasionally with particular case reviews, they felt that the healthcare team weren't sort of pushing them as much as they could do.
So that's a sort of proactive role that they want healthcare to take, so giving more leadership. What about the reactive role of healthcare? Were they there when they needed them in emergencies to escalate somebody to, or do you not have an impression on that?
I don't have very much information about that, unfortunately.
During your Verita interview, so this is just for the chair's note at page 10, but I'll read it to you. You said, Brook House, as I understand it, uses constant watches for people on ACDT quite liberally. So at any one time, there was almost always at least one constant watch happening. And this was in the context of when you were talking about levels of staffing, I think. With regard to the liberal use of constant supervision, are you intending to be critical of it, the liberal use, supportive, or is it just the size of the population?
I'm not sure. It was just that, as a matter of fact, it seemed that at Brook House they used constant watches quite a lot, and that I think generally speaking in detention centres but also in prisons, people are quite wary about putting people on constant watch because it's quite an extreme measure. But my impression was that staff themselves thought that constant watches were used quite a lot, and I think comparatively Brook House might have used them quite a lot.
What do you mean by quite an extreme measure?
It's very invasive because there's somebody literally sitting and staring at you, including when you're asleep or in sort of arm's length from you when you're using the bathroom. So it's not a particularly dignified process. It also doesn't have any ostensibly curative function. It is purely a way of watching somebody. So it's almost a bit more like surveillance, really, than it is anything that's helping somebody.
And did staff express any view on whether they thought the number of monitoring ACDT supervisions was too high or not high enough?
I certainly heard a couple of members of staff say that they thought they were used too often. So, for instance, I think more or less automatically somebody would be put on ACDT if they had refused food and fluid a number of times, which obviously maybe 3 times. That obviously sounds very serious, but they would say in some cases if they were aware that they had food from the shop, for example, even though they hadn't had a particular hot meal on the wing, they knew that a person had eaten. And if that then led to somebody being on a constant watch, they might have said that they thought that was excessive. I think I remember people saying things like that.
Did you speak to any detained people about their views of being on supervision?
No, I don't think I spoke to any detained people about their experiences of being on ACDT or being on a constant watch or anything like that.
Paragraph 53, you sat in on an ACDT review. Paragraph 3 of your statement, you described this, which was conducted, in your view, in an inappropriate place. Can you tell us where it was held?
So in this case, I think it was held in the E-Wing staff office.
So who's there at such a review? The detained person?
So the detained person was there. I think possibly a member of the senior management team was there who I might have been shadowing that day. Mm-hmm. Then possibly a couple of DCOs. But in that case, what was happening was other members of staff were going in and out of the room an awful lot because it was their office and they need to go in to pick up things. Or you would have detainees at the door kind of walking in or banging at the door. So it wasn't very private or very confidential.
And for those of us who haven't seen an ACDT review, what sort of things, just in general terms, would you be discussing with the detained person at such a meeting?
In principle, I suppose they might be discussing anything. They would be discussing the sort of sources of their distress. In this particular case, the substance of the ACDT review or the substance of the person's distress was really to do with, I think, prolonged detention. And so essentially the ACDT review just became another vehicle for yet another discussion about their immigration case. So that was overwhelmingly what was being discussed at that review, as I recall.
And as far as you can recall, or if you knew, was there any reason why it was being done there and not in a more private room?
I'm not sure why it was being done there. It might have been that they more or less made an improvised decision to kind of turn this into an ACDT review because the person had been very unhappy and was behaving in quite a difficult way for staff to deal with. And so I think they sort of said, right, we might as well kind of turn this into a more formal ACDT review. That, I think, is what I recall happening, which was perhaps why it took place in that setting.
And did you see other ACDT reviews?
I think I saw maybe 1 or 2 other ACDT reviews, and I think I had previously at another piece of research at another immigration detention centre had also seen an ACDT review somewhere else.
And do you know where they were generally held at Brook House, or where they were meant to be held?
I'm not sure if there was any particular places. It would typically be somewhere quiet, somewhere private, and somewhere kind of calm. So sometimes there would be parts of a wing that were like that. But it might have been you would take them to somewhere else. So you could maybe take them to the healthcare units or somewhere like that.
On to what staff told you about self-harm. So this is your paragraph 34. You say that a minority of staff you spoke to said self-harm was sometimes used as a form of manipulation. At 35, you form the view that some staff felt they had to evaluate the authenticity of a detained person's pain or question their motives. And you say at 36 that they were aware from training and policies that they had to take all self-harm seriously, but they felt that practical experience had taught them otherwise. Regarding the use of self-harm as a form of manipulation, Who held these views? What level of staff, or was it across the board with different roles?
I should say it was a minority of the staff that I interviewed who expressed this to me, but I heard it from DCOs, but I also heard it from managers as well.
And what was the, if they told you about it, the attempted goal in this manipulation?
So what the idea was that self-harm was being used as essentially a form of protest, or in some cases they would say that it was just merely attention-seeking behaviour to get something that they wanted. So somebody would, for example, cut their arm or injure themselves in some way in order to get something that they wanted. That was what some members of staff said to me that some self-harm was.
Any idea about what they might have wanted that this would lead to?
I heard some members of staff say that it could. They thought it was something being used for very frivolous or trivial things. So, for example, to get access to a television or something like that. So it sounded quite flippant when they said that. But it also might have been, in more extreme cases, it might have been because they were pending removal, and so it was a kind of last-ditch attempt to resist removal from the country or deportation.
I know you only spoke to a small number of healthcare staff. Did any healthcare staff you spoke to hold similar views?
I can't remember if healthcare staff held similar views about self-harm as being manipulation or anything like that. I don't recall whether or not they said that.
And again, bearing in mind it's only a minority, so a small sample size, but were these views expressed by newer members of staff, longer serving, or no real correlation?
Both. I certainly heard them from longer serving members of staff.
And did you see staff treating detained people in a way that suggested they believed they were putting it on, or was it just your view from what they told you?
This was primarily from what I had been told. As I say, in terms of the actions that I saw, generally speaking, they were done, ACDT reviews and so on were done quite diligently and were taken fairly seriously. One thing I could maybe add, I don't know if it's relevant here, is that I do remember a member of staff saying that they had, of all the new detainees that they had received in the previous 2 months, 20 of them should have been on open ACDT form when they arrived, but only 8 of them, they had been made aware of the fact that they were on that. So they were also sometimes receiving people into the centre who were high risk, but staff hadn't necessarily been made aware of that. So that was a concern.
How did they come to find out that there should have been 20, but there was only 8?
I'm not sure how they came to find that out, but it was someone sufficiently senior within the organisation that I would trust what they said about it.
At paragraph 36, you mentioned that this hierarchy of what is considered to be serious self-harm created a problem for DCOs and DCMs if they were dealing with several at-risk detainees simultaneously and trying to decide who to focus their time and effort on, especially in periods where staffing levels were low or there were other issues to deal with in the centre. So that's an issue about prioritisation, effectively, of people who need help. What did you see or hear about these prioritisation issues?
So what I heard from certainly one DCO was that he said that in some cases people are very intent on ending their life or self-harming very seriously. In other cases they are doing it for attention or they are faking it or something like that. And he said that the reason that that frustrated him was that he has to make choices about where he devotes his time and energy. There are a limited number of staff. Staff are often very overstretched, as we've already alluded to. And so he needs to decide which person to take seriously. He privately feels that one of them is much more deserving of his time and attention than another one, but he's supposed to take them, I suppose, equally seriously. So, as you say, it's a problem about prioritising your time when you've got limited resources and limited staff.
And did you see for yourself any responses to self-harm or suicide risk events, for example, a call-out? Were you present at any of these responses?
Yes, actually, one of the interviews that I was doing with a member of staff was cut short because a detainee was banging the door. He was in the care and separation unit, so the segregation unit. He was banging the door very loudly, and then another member of staff came in and said to us, he's self-harming. So I stayed. I kind of hovered around briefly, but I didn't want to sort of pry. And we agreed that we would obviously terminate the interview, and he would deal with that, and we would meet up at a later date. So, in that case, I heard somebody, I think, punching a cell door very loudly, and then I think he'd also cut himself. And so staff were dealing with that immediately.
And the person you were speaking to, were they a DCO?
They were a DCO, yeah.
But you didn't attend the event. Did you speak to anyone afterwards about what had happened or how they'd dealt with it?
No, I didn't speak to them about that particular case.
Can you comment, if you're able to, on prioritisation of responding to more violent, disruptive events versus self-harm or welfare events?
Can you clarify what you mean?
So you talked about the need to prioritise time when there's a couple of people who need help because they are at risk or vulnerable. There's obviously also a need to deal with any disruption within the centre of people who potentially, as you say, needed an unplanned use of force. Did anyone speak about any tensions between those two types of event that might materialise?
I don't think anyone spoke specifically about that, no.
In relation to this sort of unplanned response that you discussed interrupted your interview, can you say from what you saw or what you were told who responds? So you say you were with the DCO, they responded presumably because they were nearby?
Yeah.
Do you know whether healthcare would always be expected to respond to a reported self-harm event?
I'm not 100% sure, but I would have thought they would be called upon immediately, yeah.
And when your interview was interrupted and you milled around for a while, did you see or do you recall whether you saw anyone from healthcare responding?
I can't recall.
You say at 35, paragraph 35 of your statement, it is to be expected that staff in an IRC will become somewhat desensitised to self-harm and other behaviours. Did you feel that staff you spoke to were desensitised?
Many members of staff said to me that they had become desensitised, and I suppose that's not surprising. They said it was shocking the first time they saw it, or the first few times they saw it, or in particularly severe cases, it would get to them, but now it had become a much more sort of routine part of working life, seeing somebody who had injured themselves.
And in your view, did that affect the seriousness, the weight they put on self-harm risks or suicide risks?
I think it could have done. As I say, in terms of the actions that I saw members of staff taking, overwhelmingly they took it seriously if and when it occurred. But in terms of perhaps making judgments or evaluating the seriousness of the risk, I think sometimes that might mean they would underestimate it.
Were you told about or did you see any specific examples of whether an underestimation or a desensitisation about the risk affected how an event was responded to?
I didn't directly see this. I heard a number of members of staff say that they had had cases where colleagues of theirs had essentially underestimated a risk, and then it had turned out that in fact someone was much more intent on ending their life or causing themselves serious harm than they or their colleagues had realised. So I heard a number of members of staff talk about experiences that they had had, but I didn't see that myself.
And how did they reflect on that? They
said that I suppose that it made them very aware that it needs to be taken seriously, and they only need to be wrong once for it to be a major problem.
I'm going to ask you about Rule 35 as far as you can comment. So you do cover it at paragraph 63 of your statement. You mention Rule 35 and the various provisions within and say that staff didn't seem to have a good understanding of Rule 35. Was that all the staff you spoke to, certain levels of staff in particular?
This was a more general impression that I got from members of staff. It wasn't something that I explicitly asked about in interviews or anything like that, though I suppose I might have had the odd conversation more informally where we spoke about Rule 35. But my impression from the few times that I did speak to staff about it was that they didn't know a great deal about or about the related adults at risk policy, but some of the policy details, that they weren't really sure about them.
What about the practical details? Did people, for example, in situations where you would have expected them to say it's a Rule 35 event, or we had to refer for a Rule 35 report, even if they didn't know the details of the policy, were they aware of its existence? Did they discuss it in circumstances where you'd expect them to?
I can't really recall very clearly. I think Rule 35, they probably would have been generally aware of its existence, and they probably would have known that they had some responsibilities to do something.
If you can remember, and as far as you can recall, was it mentioned in relation to the management of suicidal intentions?
I don't particularly recall it being mentioned in that context, although that is one of the conditions for it, but I don't particularly remember it being recalled. That was much more discussed in terms of the ACDT policy. So
whether or not through the Rule 35 process or with regard to any particular policies, was your impression that staff referred detained people with possible suicidal intentions to a doctor or to healthcare?
I'm not sure because I wouldn't have been directly observing it myself, but I would have thought that, yes, they would have been doing that, yeah.
But you didn't specifically ask them about how they managed somebody who presented with suicidal intentions?
I can't remember specifically asking about what exact process they followed, no.
On then to victims of torture. Duncan Lewis have requested that I ask you something about something you said in your Verita interview. The reference for the transcript is page 18. You referred to a detained man you spoke to while you were in Brook House. Then afterwards you read about Panorama in The Guardian, which said that a man's deportation had been blocked as he was a torture survivor. And you thought this was one of the men that you'd spoken to while you were there. Duncan Lewis believed this is one of the people they're representing, who we're going to refer to as D668. Do you remember speaking about him to Verita?
I remember mentioning it to Verita. I don't remember a great deal about the conversation that I actually had with the man.
Do you remember speaking to him at all?
Looking at this, there were two people that I spoke to in Brook House who I think told me that they were torture survivors, so I'm unsure which of the two of them it would have been.
And recalling the people who you spoke to who said they were torture survivors generally, whichever one of them, did this lead to concerns? Did you have concerns about them being detained in circumstances where they said they were torture survivors?
Yes, I did, and I think, I can't recall if I mentioned it to a member of staff. I might have done, and I also said, I think I said to the men themselves that they should make staff aware of that fact if they hadn't already.
Can you recall whether or not they said that they had already made staff aware?
I think they already had done.
And did you ever, while you were there or afterwards, understand any conclusions about why they were there, nevertheless, having said that they were tortured?
No, I didn't. I don't remember anything about that.
And you may not remember, but you said to Verita after mentioning this person, who we think is D668, there sometimes was concern that particularly the healthcare manager at Brook House could have done more to press those issues and to ask questions and to say, what's happening with this person's case? We're concerned about this person. So when you mentioned concern that the healthcare manager could press more, was this a concern that the detained person mentioned to you, a concern that you developed, a concern that staff told you about in their interviews?
From recollection, it was a staff member mentioning that they thought that the healthcare team could lead a bit more on these cases and like we were saying earlier, could perhaps be more proactive.
And we're moving on to adults at risk now. So in your own words, if you're able to help us, what's the purpose of the adults at risk policy in a setting like Brook House?
So as I understand it, adults at risk I think was introduced in 2016, so not that long before I was in Brook House in 2017. And it's essentially to sort of strengthen the presumption against detention, it's to formally identify people who are at risk as per Rule 35, at what level of risk they are, and then they are classified as being at level 1, 2 or 3 in an escalating severity. So being an adult at risk level 3 is the most serious.
Thank you. We've heard some other evidence about that this morning, so I won't press you to give any further details. But reflecting on what you heard about it at the time when you were at Brook House, you say, paragraph 63, decision-making on adults at risk was not very transparent. Can you help us with what you mean by that? In what way was it not transparent, very transparent?
So I think I'll probably be referring here to the fact that this was again a manager or senior manager, in fact, who said that people who had been recognised as an adult at risk had kind of bounced around between level 2 and level 3, and then perhaps back to level 2. And they might, I think this particular person had been detained for a long period of time, and there seemed to be no certainty about what was going to happen. So again, not proactive enough.
So lacking transparency because we didn't know what was happening, no certainty about where it was going.
Yeah.
And I think the man that you mention is somebody you spoke to Verita about. You mentioned him at page 17 of the transcript. This is a man who'd been detained for a long time, and you say with various levels of risk. We'll refer to him as D1531. So you attended a meeting where he was discussed. This is where you came to learn of his adult at risk history. And you heard he'd been detained for 2 years. His risk had been taken from 3 to 2, and no one knew why.
Yeah, so from memory, I think one of the person leading that meeting said that this person, I think, had previously been at the highest level of the adults at risk policy, level 3, and then they had been dropped down to 2, and they had also been detained just for a very long time, and that they didn't really know a great deal about what was happening to that person.
And did they say, if you can recall, whether they had any plans to find out what was happening or why risk had changed?
I can't remember what they said about that.
And you've referred to the person who was leading the meeting. What sort of staff level would that have been?
They were in the senior management team.
And was it a formal meeting under the adults at risk policy?
I can't remember if it was a formal adults at risk policy or it might have been a more general sort of weekly security meeting. I think it might have been.
And what concerns did you have at the time, if any, about the way that the meeting or the detained person was being dealt with under adults at risk?
I should say that this was everything that I'm saying now is based on what members of staff were saying about their concerns,
yes,
rather than my own. So they were concerned firstly about how long he had been detained for. I think they said 2 years. I'm not sure exactly how long, but at any rate, a very long time. Mm-hmm. And they felt that he was stuck, essentially. There were quite a few people who were something like that, but they said that his was a clear case of someone who was stuck for a very long time and they didn't really know what was going to happen about that.
And do you recall who else would have been at the meeting? Was it a large meeting? Was it just a couple of people? It
was relatively small, but I can't remember exactly who was there.
And do you know what their roles were in what their knowledge of him would have been?
I'm sorry to say I can't remember.
No problem. Can we move on to Rules 40 and 42? Are you familiar with these? Rule 40 is the power to remove someone from association. Mm-hmm. 42 is temporary confinement. Is this something you witnessed while you were at Brook House, the exercise of these two powers?
I think I did witness it, and I certainly would have heard it being being mentioned to detainees, sort of saying, if you continue to do this, you will be on Rule 40 or Rule 42.
And is it something that you came across or heard about as a means of managing vulnerable detainees or detainees with mental health issues?
I don't recall any examples of that, no.
You said you spent time, significant time on E-Wing, or you were able to go around E-Wing. As a general sort of picture, what sort of people were on E-Wing at the time that you were there? Why were they there?
So it's a smaller unit, and it would typically be people who were identified as being vulnerable in some way. Sometimes people, if their behaviour had been quite difficult or if they had been disruptive, they might have been there. Adjacent to E-Wing was the so-called care and separation unit, the segregation unit. But in E-Wing itself, it would typically be more sort of vulnerable detainees would be held there.
Moving on to paragraphs 30 to 31 of your statement. Sorry to jump around it.
Sorry.
You refer to detained persons' complaints and concerns. Where you refer to detainees' complaints, are you talking here, just to clarify before we start, about complaints as in things they mentioned to you or complaints that they made through various complaints processes?
And things that they mentioned to me, so not things that they'd mentioned to the PPO or anything like that.
And you say that there were complaints about Home Office processes relating to the fact or duration of the detention and planned deportation. How common was it that detained people would complain or speak to you about those sorts of issues?
I mean, pretty much everyone was unhappy about it, so pretty much everyone would mention that.
You also said that there were consistent complaints about material conditions like the quality or variety of food, ventilation in cells, healthcare, quality of legal representation, support for detainees who are really struggling, and many other individual issues. And you heard a range of these things from different people. Did detained people tell you whether they'd made these complaints to anyone else or just to you?
They didn't tell me who else they had made them to, but they would often be expressed to DCOs or DCMs. I'm unsure to what extent detainees made use of formal complaints procedures or anything like that, but they certainly were quite vocal about their unhappiness.
Did you discuss with them official channels through which these could be raised, or did you have any view on their knowledge of their ability to do so?
I don't remember speaking to them about formal complaints procedures or how aware they were of them.
I finally wanted to ask you about senior management. So what was your exposure to senior management while you were at Brook House? Did you see them on the ground, and if so, how frequently?
So a couple of members of the senior management team, one member of the senior management team in particular, I spent quite a lot of time with. Others, I maybe interviewed them, so would spend maybe an hour or a bit more speaking to them, but wouldn't be seeing them on a kind of day-to-day basis, or might have seen them on the first day I went in and on the final day before I left. So there was one member of the senior management team who I spent quite a lot of time with, but the others I didn't see a great deal.
And what about their interactions with detained people?
So the member of the senior management team who I spent a lot of time with seemed to be slightly more involved in the kind of operational aspect of the institution, as well as the kind of higher level or more strategic or managerial role as well. And so I was with that person when they were going around the wings, when they were speaking to detainees, when they were checking in with staff, and so on and so forth. So I saw them in a more operational role, as well as getting to know them, and they're getting familiar with their sort of management perspective as well.
That was Michelle Brack.
Yeah.
And what about senior management's interaction with other members of staff, for example, DCOs, DCMs? Did you see discussions, meetings, briefings?
I saw maybe a small number of them, but in terms of actually observing the relationship between members of staff of different levels of seniority, I didn't see very much of that.
And did you speak to staff about their relationship with senior management?
Yes, I spoke to some DCOs and probably also some DCMs, particularly detainee custody officers I spoke to about their relationship with senior managers. And in some cases, they certainly said that they thought that the senior management team were quite distant, or that if they had particular problems, they would more likely resolve them with their colleagues or not raise them at all because they felt quite disconnected from the senior management team. I don't remember that being an especially concerning thing. I thought that's probably quite a common thing to hear in an organisation, but I certainly heard some people say that.
And thinking particularly about vulnerable people at risk of self-harm or suicide, did you gain any impression of the role of senior management in dealing with those people?
I didn't gain much insight into the specific role of senior management, although like I was saying earlier, in some cases a senior manager would be expressing their frustration about a particular case and saying that not enough has been done about this. Or, as I mentioned earlier, a different senior manager mentioned to me that they had only received 8 out of 20 open ACDT referrals in the past 2 months. So that was all I saw.
I have no other questions for you, Dr. Aitken, but I'm going to ask the chair whether she has anything to ask you.
Thank you, Ms Moore. I do have a few. Thank you. Firstly, I wonder, Dr. Aitken, if you could just give us a little bit of context to when you will have been agreeing your research project. I would imagine that there will have been some sort of ethical framework process that you will have gone through to firstly agree the research, and then some ground rules potentially of what would happen when you're on the ground at Brook House. Mm-hmm. Perhaps you could just give us a bit of context about whether there was any expectation on you to whistle blow. Were you kind of given a guide to the kind of things that you should report on if you observed things, or not report on if you observed things, if you were there in a capacity as a researcher? Would you be able to just tell us a little bit about that? Yeah,
so there was an ethical guidelines process that I had to go through at my university, and then the arrangement for me to actually go into Brook House to carry out this research was done quite informally, so there wasn't any kind of form. I had to get Home Office clearance to do research in IRCs generally, but then this specific project wasn't sort of formally approved. It was much more informally arranged between my supervisor and someone at Brook House, or a group of people at Brook House. When I got there, no, I wasn't told anything about specific whistleblowing procedures. I wasn't told what to do if I observe someone doing X or Y. I don't recall hearing anything about that.
Okay, thank you. And in this sort of similar theme, do you recall any conversations yourself about being warned about the risks of conditioning, risk to yourself, the need to be vigilant, any of those types of conversations?
I remember having a few quite informal conversations, usually with DCOs, detainee custody officers, about the risks of conditioning, and they were saying it for other members of staff. I don't think they were warning me about it particularly. They might have been by implication, I'm not sure, but they certainly would mention it informally. And likewise, were you ever given any information about your own ability to highlight if you felt that a detained person may be at risk? I wasn't given much information about that, no. I don't recall being told what to do in that kind of situation. I think I might have informally agreed or said early on, that if I had very serious concerns about a particular detainee, that I would report it, or I would say to that detainee that I would need to go and tell someone about this. But that was, again, I think that was a fairly informal arrangement. Okay, thank you.
also, just a little bit more about context. Could you tell us a bit about, were you able to go in whenever you wanted? Could you go in at different times of the day for different shift patterns, different days of the week, or did you tend to have a more routine, a kind of regular routine of when you went into Brook House?
Yeah, I went in entirely on weekdays, so I never went in on a weekend, and I typically did, well, I was going to say working hours, but every hour is working hour for them. But I would typically go in roughly between 9:30 and 5:30. I mean, it took me quite a long time to get there and get back, so yeah, but I was never there at night. I was never there past 7 p.m, I don't think, and I wasn't there on a weekend. Okay,
thank you. And final question about the kind of specifics of your research. The people that you were able to interview, did they self-select to be interviewed, or were you able to say, I'd like to speak to you? How did that work?
So, from what I recall, there were a number of people who I'd gotten to know a little bit, and I'd said to them, oh, would you be interested in speaking to me at some point? But then, when it came to actually sort of timetabling it, obviously, like we were saying earlier, there are concerns about staffing, so it's difficult to arrange, people to have an hour or something to be interviewed. And so it was Michelle Brown, I think she was newly the head of security at that time. So I'd said, would she be able to kind of help me come up with a kind of timetable? And also I said, would it be possible for you to sort of suggest some people that I speak to across a range of factors, so men and women, members of staff of different ethnic groups, different age profiles, different length of service, different levels of seniority. And I think there were also, so she was very helpful with that, but then there were also some individual members of staff who I was able to arrange to have an interview with. I should also say that interviews they proceed on the basis of informed consent, so a member of staff could decline to be interviewed, but I think in the main people were fairly happy to speak to me, of the people who I spoke to.
And did that apply for detained people as well? That could you kind of just ask people if they would be interested in speaking to you, or people could come forward and say that they would like to? How did that work?
So I made a decision that because of the nature of what I was researching, I didn't feel it was appropriate to do formal interviews with detained people, in part because many of them might have had very distressing experiences, and I didn't really think it was ethical for me to bring that up, and also unlikely to have very much tangible benefit to them. So conversations that I had with detainees, I had in the first couple of weeks that I was there, and they were on a much more informal basis. So I would go one day and spend time on B wing or C wing, and I would chat to anyone and everyone who I saw around. So people on the wing, on the residential unit, people in the courtyard, people in the kind of recreational areas or whatever. And we just have much more informal conversations with them. Sometimes they lasted quite a long time, and sometimes I would sort of jot down notes from what they said, but they weren't sort of formal interviews, so that was just anyone who I encountered that I was speaking to.
Thank you. And my final question, and do feel free to just say that you can't answer this if it's not an observation that you feel able to make, but based on your experience of having been in other IRCs as well, was Brook House different in general to other IRCs that you had experience of? Was there anything that struck you as different particularly?
I don't recall there being anything especially unique about Brook House. One of the things that I suppose you might notice is that it's quite small and it feels quite cramped, so there's very little kind of natural light, there's relatively little kind of ventilation, and it was also at times very noisy on particular wings, especially if the door was closed, so people would kind of batter the door, and the sound, echoes, and it's quite kind of overwhelming at times. Other times it can be very quiet. So I recall that about Brook House, and people often complained about things like ventilation in their rooms or cells. It was quite similar to Colnbrook, and it's physically extremely similar to it, and also was quite similar in terms of the kind of feel of it, for want of a better term. But I don't remember there being anything especially unique or sort of singularly important that I would note about Brook House rather than any other detention centre.
Okay, that's very helpful. Thank you very much. That's all the questions I have. Thank you.
Thank you for coming to give your evidence.
Thank you.
I'm very grateful. I know it's not an easy experience, and so I'm sure you're glad to have it over with, but it's been very helpful, so thank you.
No problem.
Chair, it's 12:15. Our next witness is Mr. Bowl. I suggest it's a bit early for lunch, so we might have a 5 to 10 minute break to set Mr. Bowl up and then start his evidence before the lunch break.
That sounds good. Thank you very much. Okay, I'll rise for 5 minutes. Thank you.
All rise. I swear by Almighty God
that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you.
Chair, we'll be now hearing the evidence of Anton Boll. Good afternoon, Mr. Boll. Could you
Morning.
please confirm your whole name?
Yeah, my name is Anton Bolle.
And we have a witness statement to the inquiry signed and dated the 19th of November 2021, which is at FWT 000001. Can you confirm that that's your witness statement?
Yes, yeah.
Chair, I will ask for this statement to be adduced in full. Mr. Bolle, this means that we are not going to go through everything in your statement. That's already there as your evidence, and there's just a few issues the inquiry would like to hear more from you
That's
on.
fine, yeah.
You were also interviewed by Verita on the 11th of May 2018, and you've confirmed in your statement that in general that account is correct. So I will ask also for the transcript of that interview to be adduced as well. That's for the purpose of the transcript, VER 000222. So during the relevant period, you were a team leader of the substance misuse team at Brook House.
Yes, yeah.
The organisation has been known by a few names, Forward Trust and RAPT.
Yeah, RAPT, yeah.
What was it called at the time?
The Forward Trust. No, it was RAPT, still RAPT, yeah, at the time. Then it changed to Forward Trust, I think, shortly after, but I don't have exact dates.
Was it the same organisation apart
Yeah,
from
the same
name?
organization, yeah.
And you and your team were working across both Brook House and Tinsley House.
In Tinsley, yeah.
So you were there on generally a daily basis within either one of those two centres.
Tinsley we covered once a week. It was mostly drop-in, but if we had clients, so then we would as well come during the week for one-to-one sessions.
And you would be, those sessions would be delivering drug and alcohol services
Yes,
to
yeah.
the detained populations. So thinking back to Brook House specifically in 2017, what might your day-to-day work have involved?
Yeah, so we would offer one-to-one sessions to residents, group work as well. We would have regular drop-ins. So on each wing we would come and really talk to detainees and deliver our leaflets. And obviously one of the most important was induction, so which was face-to-face. So all new arrivals, so we would see in face-to-face and give them induction pack and try to explain them as well harm minimization advice, danger of use of drugs, mixing drugs, and all similar advices. Yeah.
Thank you. I'll ask you more about those different stages in more detail as we go on. So you're still working at Brook House now?
Yes, yeah.
But since the 1st of September this year, the Substance Misuse Services has now come under the umbrella of healthcare.
Yes, yeah.
So you're now working for the Practice Plus group, which we'll call PPG, who now provide healthcare, but substance misuse is now part of that same
It's part of it, yeah.
When you were managing Forward Trust, that was 3 of you.
3 of us, yeah.
And I understand that now you're part of PPG, there's just 2 of you.
Yes, but we just had a new strategy plan, which was agreed just recently, and we will employ 2 more staff, part-timers. So we will be like then 1 full-time, 2 part-time, and me. So we will expand, so which is good. So we will be able to cover as well more Tinsley.
So the 2 part-time staff, will they be 0.5 full-time equivalent?
Apparently it's 1.2.
Oh, so
Yeah,
0.6
1.2, yeah,
each.
shared between 2
Is there any
workers.
reason for having 2 part-time rather than 1 full-time to replace that last role?
I didn't really inquire, but we are extending our services to Saturday and Sunday. It might be easier because we had really a lot of problems to employ and find appropriate persons who would work. So eventually, with the Forward Trust, we had to employ 2 ex-officers and train them. But probably part-time, it would be probably easier to find someone who would agree to work at Brook House.
During the relevant period then, so 2017, did you do weekend services, Saturdays and Sundays?
No, we didn't. We did try weekend services, sort of as a pilot project, But detainees that didn't really engage during weekends because their head is mostly, I work from Monday to Friday, I got hearings, but Saturday, Sunday I want to rest. So that's why we stopped then, because on request of senior management, and we piloted it for I don't know for how long, but it wasn't really successful. Yeah.
Your team, being Forward Trust, was previously independent from healthcare, so it wasn't part
Yeah,
of
we were
G4S.
independent. Yeah.
And it obviously wasn't part of G4S that were generally running the centre either, but you worked with them.
I worked with them, yeah. So we had a meeting, because I was sort of like, I was managing the team, so I attended all meetings which were needed as somebody who is service manager would do that.
Did you consider the independence of Forward Trust from G4S and G4S Health to be a benefit?
Yes, I think, yeah.
In what way?
Because we could really raise the issues, and obviously there was no fear there will be repercussions or whatever sometimes you might think. And obviously we could consult as well independently. Is that the best option? Yeah, that especially that. Yeah.
So you're not part of the company that are running the detention side of things, but you are now part of healthcare at Brook House.
Now, yeah, we are part of healthcare, yeah, since the 1st of September.
1st of September. Do you have any concerns about the fact that you're now not independent of healthcare, that you might not be able to raise issues in the same way you could before?
I mean, it's the early stage, I would say. So we are only since the 1st of September within healthcare, and it's still like a foundation time. But I do think so. We are going to be part of mental health team, integrated mental health team, and because 50% that about our clients, they got mental health issues, it does make sense to work closely. So I do agree with that, yeah.
So it makes sense to work closely with them, but you have...
Mental health, yeah.
But you're part of the general health services, not just mental health.
Yeah, part of general, but we will have own lead for mental health and substance misuse. So there's some sort of independency there.
At paragraph 11 of your witness statement to the inquiry, you set out the service delivery at Brook House, which is assessment and support for residents. And you say there, and I'll read it out, interventions included assessment, agreement of recovery plan objectives that could include harm minimisation advice, one-to-one sessions, group work sessions, joint clinical reviews with main substitute prescribing team, and holistic therapy options such as auricular acupuncture. Just on that initial assessment, was this once someone had been referred to you, or could they turn up to get your help to have that initial assessment done?
Yeah, so but basically we would receive, it is possible to refer from other teams like healthcare at that time, or even home office, so whoever, or even officers from the wing, and obviously we would then have initial assessment where would we assess them, and really care plan as well, what the most appropriate intervention would be the best for them. And obviously after Verita report, so it was recommended to move us more central, because we were before in very isolated area, in sterile area, where detainees couldn't come and see us. So after that recommendation, we moved to more central position, and we would then experience increase of detainees coming to us
Sort of drop-in,
which was really good. Or we had peer supporters as well, always where normally I would train them, and as well then they could talk to me. Normally I would supervise them, and they could come freely to me, which was good as well. Yeah.
So thinking of a detainee who you've never met before, so somebody who you have for their initial assessment, you say you can develop a care plan, you take into account their history, presumably of any substance issues in their history.
Yeah.
How much do you take into account other aspects of their clinical history?
Yeah, so we obviously, we would ask other questions. We had risk assessment as well. So where we would discuss, are there any mental health issues, any social, for example, child issues as well. So we would go through them.
Sorry, any child issues?
No, I mean, sorry, it's like if there is children involved, like they got family, with whom they live. Sometimes it's known that if both parents are addicts, it can be quite detrimental for children. So we would refer to social services if anything like that happened. So it was sort of holistic, quite holistic care plan.
And did you work with, thinking of 2017, did you work with healthcare at all to understand the picture of somebody's clinical history or mental health history, or did you do that standalone?
Yeah, no, we had access to System 1, which is which doctors and nurses would use. So we could refer people to System 1. We could read the notes. Obviously, we had meetings as well, regular meetings. Quality meetings with healthcare, and then every 3 months as well, meeting with commissioner, NHS commissioner. So sort of, I did feel that we worked together.
So System 1 is the sort of online database that you can access somebody's medical records,
so where all
make notes.
Clinical notes are, and as we could see as well medication, because it was important. Some of our clients were on methadone. And normally, obviously, we would have complex case meetings, we call them, with doctor and with the client, and me. And then we would discuss any issues regarding methadone prescription. It was quite good because sometimes a doctor really motivated them to work with us because they could see that we work together.
So those, for example, who were on methadone, would they be primarily dealt with healthcare, or would you have the oversight of their prescriptions and drug management?
No, yes, obviously, because I'm not medical educated, so it would be healthcare, but psychosocial part, it would be us.
And I think you mentioned you could also refer residents to healthcare if in the assessment you felt they needed.
Yeah.
Would that be for mental health issues as well as prescription and
anything? Anything related to healthcare.
So if you could help by giving us a general picture and thinking about the relevant period, which is April to August 2017, what drugs were most common at Brook House?
Yeah. If I remember, it was mostly spice and cannabis, so that we wouldn't have much of other drugs. We would get occasionally crack cocaine. I don't remember heroin was much present. So that would be basically,
Spice and cannabis. And you mentioned in your witness statement hooch, so homemade
Huge, of course,
alcohol.
Sorry, huge was quite, especially with detainees from Eastern Europe. It was really quite prevalent,
And would that be something that, as far as you knew, was produced within Brook House?
Within Brook House,
You've mentioned spice, and you mention it in detail in your statement. And we've heard evidence in the last few weeks about spice and spice overdoses. But perhaps you can help us understand it a bit more. It's a synthetic substance.
Yeah, it's a synthetic man-made drug which mimic the effects of the active ingredient in cannabis, the THC, and which gives you feeling to be stoned. There might be powder chemicals dissolved and sprayed onto paper or dried plant material. And it was as well becoming more and more common to find it as liquid. So it would be sprayed on paper and sent to the post. And I don't think we had really control over posts because it's obviously you couldn't really recognize, or as I'm aware.
So you couldn't tell from looking at a piece of paper whether or not it had been sprayed, as far
I
as you
haven't
could tell.
seen it, how it looks when it's sprayed, ever, but it just the sheer amount of post, because I think it's just only one prison, GFRS prison, had this facility to check it, if I remember, but don't get me, I'm not exact on that, yeah, but that was, yeah, and obviously then smoking is one of the most used method of spice.
So how do you smoke it? So for example, say somebody has paper which it's been sprayed onto.
It's like tobacco, and you can put in tobacco as well, and it's just roll it and smoke it. And the problem is that you never know what you get. It's a Russian roulette, so because it can have very bad effects. It can really relax you, and you feel nice, stoned. It can have like a depressive effect. Next time you can have stimulant effect, because it's all be man-made, and you wouldn't know what it's in. And if somebody's got heart problems, high blood pressure, once he really was relaxed, the second he end up in hospital. So I heard as well, when I used to work at HMP Coldingley, there was a prisoner who actually got blind. So it's rare, but that was, but mostly it's really inability to move, breathing, difficulty, heart palpitations, extreme anxiety. So I've seen guys who were long on spice with heavy paranoia. That's quite
What, seizures?
Seizures as well, yeah. So yeah, well, of course.
And I think you mentioned that it's like a Russian roulette.
Yeah.
So you don't know what's going to happen when you take it.
Yeah.
And is that because you don't know what the dose is going to be, because you don't know what's in the batch, or a combination?
Yeah, you don't know why. Literally, they're inventing constantly new chemical structures, so you really don't know what you get. And obviously, they are using sometimes the most vulnerable detainees as checkers to check the batch, so which is another problem. So they are aware of the risks, dealers, but obviously they're checking batches, and if they see it's okay, then it goes around.
So we'll come on to that, which we've heard referred to as using a detainee as a guinea pig to check the batch.
Yeah, it's guinea pigs, yeah.
Just before we leave the overview of spice, I think you said that you can sort of feel stoned or relaxed. Is that, as far as you understand, the desired effect? So when people take it, the intention is to feel relaxed?
Yeah. Especially, obviously, in such an environment, which is very distressful. So obviously to experience it's like a relaxation, or sort of getting away from all the situation.
You told us at paragraph 49 of your witness statement that there's some residents you worked with who had previously used drugs, and there was others who only started them when they were detained.
Yeah. So when I started, I came from HMP Highdown. We started the service, and what really surprised me, we had so many referrals, still in my head, so many referrals of detainees who actually really started to use at Brook House, which, because normally I was used to, from prison there, we would have people who were drug addict, and obviously they would admit and they would access our services and we would help them, but not many would start in prison. There would be some, but really not a big amount of prisoners I would. But here, at that time, it was more than half, even I think it was 80% was really just first time.
Is that more than half of people who took spice, or more than half of people who use drugs generally?
No, so we had a lot of referrals. So, and from then obviously at that time I was alone. So actually I went to see all of them, and that's where I got this data. So that it's it is really most of them were first-time users.
Of your referrals?
Of referrals, yeah. So there were referrals from security, healthcare, officers.
And when we talk about people who start to use drugs in Brook House, are we generally talking about spice for first-time users?
Spice, yeah, and cannabis as well, yeah. Crack cocaine could be as well, and huge, yeah.
And can you tell us, as far as you know, about why people would start to use drugs from your experience when they were detained at Brook House, when they hadn't before?
Yeah, so mostly it would be really to try, obviously to distress. Yeah, so they were stressed, obviously it's a sort of self-medication. And then obviously it was as well, I think, around Christmas can really increase. It would be then as well missing family.
Why would it increase around Christmas?
So especially they can't see family, children, partners. That was quite a big factor as well. And obviously everyone is partying. They got some nice time. And me, I'm in detention center. I don't know even when I'm going to be released. So it's sort of quite daunting.
Anything about the type of person who you saw who might be more likely to start using when they were in detention, or was it difficult to predict?
So it was interesting. They were young, they were old, so you couldn't really. But some, I would say, a bit naive. So that's why we introduced after that inductions face to face, not in the group, where we could talk to them in person and warn them. So and I think after that the numbers really went down. Yeah.
And you said that people can use it to de-stress, so to relieve stress.
Yeah, sort of to forget all sorrows. And
did, in your experience, people start using drugs at times of other types of mental ill health?
Yeah, it can be as well. So yeah, we had dual diagnosis, self-medicating.
What sort of dual diagnosis would you have?
I mean, we had people with anxiety, then schizophrenia as well, psychosis. So it's quite, I would say that 30% of our clients at least had dual diagnosis, so who we saw they were engaging with mental health.
And you've mentioned to us already this afternoon, and you also say in your witness statement about vulnerable residents who might be used as guinea pigs to use spice batches. How often did you see this sort of thing happening?
I mean, I didn't see often, but it did come to my mind. You could, I remember certainly a detainee from Ukraine who was, you could see that he was very vulnerable, and as well, you could see that they were using him as a guinea pig. So that is, for example, and obviously he didn't want to engage with us as well.
He didn't want to engage
with our services.
Why not?
We just said no. I think it was maybe just pressure from drug dealer, or because maybe fearing he will get some information.
And you say, presumably as well as seeing it, you sometimes heard that this was happening, but they didn't end up referred to you. Is that fair to say?
They were referred, So the officers are quite good in security. So if they see someone that...
So you just lean forward so the microphone picks up what you're saying.
If they see someone who is using, we would receive security referrals quite often. And as well, for a few years, not that I'm running drug and alcohol courses for all new officers, where I as well explain and encourage them. Always, it's not... they can always refer people to us, even if it's the second, third time, because sometimes they might engage with us if we come to see them second or third time. So we got a good number of referrals. So I can't complain with that. There is awareness. But obviously, the second is some of them, they won't engage. Some of them, they will think, okay, that will be on Home Office records. So and I will be deported. So it's really important we explain them so that Home Office is not after you, so it's really helping you. They never came and asked us for your records. It's actually, if it's on your record, that will actually help you, because obviously you've done some work, and that probably judge will be more happy if you've done it than not. So when they understand that, so then they would engage, many of them.
So just to finish the point about the people who were used as guinea pigs or for testing, and you said this happened not often.
I mean, it happened, obviously, not in front of my eyes, so that I would be aware.
But
so
you heard about it.
Yeah.
And when you say not often, do you mean only once a year, only once a month,
not often,
once every 10 years?
Not often that I was aware. So that means, so obviously I was aware of just a few cases, but I do believe it was happening, because when the spice was present, they did check it, I believe, always.
So every new batch would have to be checked in some way?
So I believe, so that they would check, unless they would just, I really know how it worked, but I would imagine,
And you say in your statement that you warn new people about cigarette spiking, so don't share cigarettes. And is that because the paper can be sprayed?
Yeah, no, they can. That happened a few times. So they would just make fun. So they would give another detainee cigarette spiked with spice, and they would just observe what happened with him. And then they would laugh at it. So it was really quite malicious.
Yes.
So we would warn them, these things are happening, happened before, so please be careful. And then as well, that there are drug dealers, they would come, they would offer you drugs. And obviously, I think that preparation for them, so that they are not surprised when somebody comes and offer, was that sort of gave them ability to say no, I do believe.
And as well as warning them not to, for example, accept a cigarette from a stranger.
Yeah, of course,
and not to accept drugs even knowingly.
Yeah.
Did you tell them what they can do if that happens to them, who they can tell?
Yeah, obviously they know that they could report to officers, but I don't believe they would, because obviously if you cross the drug dealer, the repercussion can be really big. So I don't think that was ever reported, or if it was, not often. So
never reported, so you never got to the bottom of who was testing the batches?
I mean, obviously, because I don't have access to security records, I hope it was reported. So actually, there was... I got one report here that it was reported, which
yes,
and I'm glad to see that. Now,
yes.
But obviously, I don't see the end of the process.
And just as to the, let's say, guinea pig testing, you're aware that it's happening even if you don't always know all the details. Did DCOs and DCMs know that this was happening?
I'm not aware that all of them would know. So it's just really how much they are sensitive and aware, because obviously, like was mentioned previous, so they were really very busy. So sometimes you can't really see everyone, what state they are, and then they were moved from wing to wing as well. I wouldn't expect really from them, but what I was expecting really, if it's something suspicious, to refer to us, which they would do now.
What about Home Office staff? Did you ever discuss this issue about people being used to test batches of spice with Home Office staff, or did you get an idea they knew that this was happening?
I think, and I've never discussed with Home Office, but I think it was known that obviously it's hard to find and to get recognition that this is really happening from the person. So that I think that the main problem would be really to admit, so that they need to admit I'm doing that, because then he would be exposed to maybe brutal abuse from dealer and from other detainees who are using, and I think that's the main prevention.
How did you know, other than it being common sense, that this was what they were scared of? Did people tell you that they had those fears?
No, obviously I experienced that before. So obviously I used to work at HMP Highdown, and there was a case when a prisoner didn't want to bring drugs, and he was beaten properly, so that somehow 4 of them managed to come in the room without guards see the officers saw them, and really he was in bad state. And then as well, where I used to live, it was in the I read in newspaper actually, but because it was at high down, so there was an officer who was bringing drugs across the drug dealers. I don't think what it was, or he didn't pay or something. They found his address and they killed him at home and such things. So it's quite. So it was in my head like common sense that they will revenge, sort of.
And did you feel that detained people shared that fear? That they would, and is that something that people talk to you about?
Because there was obviously here, in number 11, so it was.
Yes, let's turn to that. Can we have it on screen? In fact, it's CJS 005089. It's at tab 10, I think.
Yes.
You're referring to rather than 11, the Detention Services Security Information Report. Is that right?
So
Ted, do you have that at your tab 10?
Obviously, I wrote SRR, so because one of my clients who used Spice recently at that time.
So I'm just going to explain what the form is. It's a Detention Services Security Information Report. It's dated 11th of April 2017. I think that's the first entry on it. So that's when you opened the report.
Yeah, when I opened it,
and that's your name there at A. So you've opened a security information report here because of a security
And obviously
concern.
you can see on the top, normally we would put names.
You'd put the detained person's name.
He didn't want to do that.
Yes.
Out of fear.
And if we turn to page 2, we can see more details about what you were told on this occasion.
Yeah.
So this is security information. There's no names, as you say, because they didn't want to.
He didn't want, and obviously I would lose his trust.
So I'm just going to read it out. Subject heading: drug supply. Content of report: during one-to-one session, one of my clients who used Spice recently stated that drugs are coming in through a member of staff. Did not want to tell me the name of person.
Yeah. So obviously his fear was, and as well as later. I was able to read James's report from detainee welfare group. So they had maybe the same client who actually was afraid really to receive revenge from officers or drug dealers who were bringing drugs now. So we had always, because I was attending security meeting, we had intels that some staff was bringing. But that's everywhere in prison. Everywhere you will have certain stuff who are compromised, but most of them might be more through visits.
Through visits, yeah.
Through visit posts as well, yeah. So.
And you said you had certain intel that staff are bringing in. Was it always intelligence you received from detained people who were using?
Yeah, this one was from detained, but obviously it was as well. Yeah, sometimes mentioned from staff. As well, obviously, we always informed security, and I've seen the security was proactive, and they did manage to stop. And some people were sacked, and they lost jobs. So it doesn't. It was dealt with, but obviously it's hard. So my understanding and my feeling is that if we were flooded with drugs, it was more likely that staff was bringing, because you can bring big amount of drugs, stuff, where to visits normally it's not such a big amount that you can really order the post.
So if we talk in terms of sort of, and we have to do it in rough terms, but in terms of doses of Spice, for example, how much would you be able to put in a letter? How many how long would that last one person, one piece of paper that had been sprayed, for example?
You would spray it on the paper, and I really don't know this one.
But you say that why would a greater volume be possible if it was through staff rather than through the post?
Because obviously they can bring in the bag. And
so a large amount in one go.
Large amount is not checked. And obviously, if you have two workers working together, two dealers, then the one go in, checks there is no searches, inform other one, it's green light, and you can bring. So that's just my.
Is that people working together? How have you got that
No,
information?
just my imagination.
I see,
Obviously,
okay,
I
fine.
never
Yeah, no,
experienced that, but
Sure.
but obviously, because normally it was unannounced. Searches would be unannounced.
So random days.
Random days, yeah.
So just going back to this report before we leave it and have a short break, or a lunch break. You filled in this report on the 11th of April 2017. You say at 11:50, and you note that one of your clients said staff members bring in. It doesn't say what drugs, but I presume it's spice because you say your client used spice recently.
Oh, probably, yeah. I'm not sure as well, but probably. Yeah,
See-
who use spice? Yeah, probably, yeah.
They didn't want to tell you the name of the person, but they told you it was a member of staff.
Yeah.
Did they say what their role was?
No, they didn't want to say
Nothing about
anything.
it.
Yeah, no. It's a sort of fear, yeah, really, that they will receive reprisal. So obviously, if staff is bringing in, then might be that he's got drug dealers in, and obviously they can go after him. So I can imagine his fear coming from there.
Sorry, do you remember specifically whether this person said what their fear was, or did they just say, I don't want to tell you?
No, just said, yeah, he doesn't want to tell me. Yeah, no.
And we can see here, just above the signature box, it says, I have not informed my line manager, presumably because you were the team leader, of the contents of this report, and you've written, but informed Deputy Director Stephen Skip instead.
That's normally, would be the procedure.
And then it's a 5-page form, but if we go to page 5, please. The document goes on to note that they don't know the name of the person who's reported it. And then the final page of the document is an email from Jason Murphy to you on the 14th of April
From Jason,
that says, you put in an SIR with regards to information given by a detainee regarding spice. Can you please identify the detainee who passed that information on to you? And if you can remember, and please don't tell us the name of the person now, but did you give the detained person's name to Mr. Murphy?
I think I answered them that person doesn't want to reveal his name and that I can't give the name. So that was my recollection.
Did you have, if you can recall, either in this instance or any other, a discussion about any protections that could be put in place so that the person could reveal further information?
Yeah, no, I didn't really talk with security. So what it could be done, because he didn't want to be noticed as well. So it would be really breach of trust, which is and it would jeopardize his security as well. It seems to me.
And were there other occasions where you were told about staff bringing in drugs similar to this one?
Yeah. There were occasions where we had this information, and obviously, so we would always write SRs from the team. But I think some detainees, they didn't have any issue to write their name or seat, if I remember well. So it's not everyone. Yeah, so. But the problem is if somebody agree to write name and seat, then it's always we're always asking, so what is this behind? Is it revenge to someone, or it's blackmailing officer, or something?
So some people didn't mind sharing their name with you, and they also didn't mind naming the person who they said was bringing drugs.
Yeah. So once, if I remember well, we had two groups bringing drugs, and obviously they were reporting each other, so sort of to disturb the trade.
This was at Brook House.
Sorry.
At Brook House.
Brook House, yeah.
And approximately when? What year?
Oh gosh, that's funny. I think it was I really don't
Don't worry
know.
about
Sorry.
guessing if you can't remember. And when you say they were reporting each other, they were reporting other detained people who were bringing drugs. Were they also reporting
so
staff?
reporting names, sort of, yeah. And that if I remember well, yeah. So that was, or at least one group.
As well as staff names, or just detained people's names?
It was detained people.
And when you had a report like this, when somebody told you information like this, would you always put in a SIR?
Yeah, of course, yeah. That was a member of staff, and it was so really working together with security.
And would you find out what happened, for example, in this circumstance? What happened?
No,
to
we
it?
wouldn't be informed because it's Intel, and obviously, I was trained of certain stuff you don't question, and because there's some sort of confidentiality from security side.
Yes. Chair, I have more questions for Mr. Bull, but I wonder if now is a good time to have a break for lunch and maybe return at 2:05.
Agreed. Thank you very much. Let's see you at 2:05. Thank you.
Thank you.
All right.